Sally, when you look at your screen, what are my eyes doing? Does it look like I'm
And
delivering?
ready when you are, Mr. Chair.
Okay. I'm not seeing everyone, so
Ready when you are, Mr. Chair.
there we go. I got the wrong view. All right, terrific. All right, let's see who's here. We've got Mr. Hyatt,
Good evening.
and we've got Cheryl and Chuck. Do we have Ms. Halleck?
Can you hear me?
I can hear you.
Let's see if I can. Oh, here we are. I apologize. There we go.
Okay. We've got Ms. Nash. Right, I think we've got everyone we need.
Andrew, I'm sorry.
We've got 1, 2, 3, 4 members of the board at least. Who are we missing? We're missing Michael. Yeah, we're missing Michael. That's
5 members of the board.
Yeah, we got 5. All right. All right. Well, we'll begin the meeting. Good evening, everyone. Welcome to the City of Annapolis Board of Appeals special virtual meeting for November 18th, 2020. This meeting is being broadcast on the City of Annapolis YouTube channel. My name is Bob Gallagher. I chair the Board of Appeals. In accordance with city policy during the pandemic emergency, this virtual meeting allows the public to observe the meeting through the video link. The public also has the opportunity to submit written comments for this meeting through an online submittal process available on the city's website. The links to the YouTube channel and to the city's website for comments should be found on this evening's agenda. We'll begin the meeting with a roll call. Ask our recorder, Ms. Hook, to please call the roll.
Gallagher,
Yes.
Mr. Zazali,
Yes.
Dr. Chen,
Present.
Mr. Walsh, Mr. Burnett,
Present.
Mr. Dews.
Present.
We have a quorum. Mr. Zazali, did you miss the last meeting?
I did, but I was able to find the file, sent the video file recording sent to me by Jackie, and I watched the entire thing.
Terrific. All right, well then you are competent and authorized to continue to hear the case tonight.
Mr. Chairman.
Sorry?
Mr. Chairman, I also was not present at the last meeting, but like Christian, I found the video and I watched the entire video.
Great, thanks for doing that. No, it must have been fascinating.
It was.
It felt a lot like this. I actually found myself talking to the video a couple of times.
Okay, so before we get into the agenda, a couple more points of information about the virtual format. For viewers who are not parties or members of the board, the people you see on the screen are members of the Board of Appeals. And right now we also have representatives of the various parties for the case in front of the board. Also participating in the meeting are counsel of the board, Cheryl Woods, our recording secretary, Tammy Hook, one or more city employees managing the broadcast aspect of the meeting. Also participating, there may be other representatives of the city, including Sally Nash, the Director of Planning and Zoning, Joelle Braithwaite, Assistant City Attorney, and Counsel for the Department of Planning and Zoning, as well as one or more other members of the planning staff. We ask everyone but members of the board to mute themselves except when they are speaking. If you wish to speak during the meeting, please raise your hand and unmute yourself, and I will call on you to speak. As I mentioned earlier, written public comments are accepted on the city's website. Comments submitted up until noon today have been made part of the record, have been forwarded to the members of the board and city staff and the parties in advance of the meeting. In order to allow additional comments relating to matters arising at tonight's hearing, the record will remain open and the hearing continued until November 30th, 2020. Additional public comments will be received until noon on that day and will also become part of the record. Have the members of the board had a chance to review the agenda for tonight, and are there any corrections or suggestions for amendments? All right, may I have a motion to accept the agenda?
I move to accept the agenda.
Is there a second?
Second.
All in favor?
Aye.
Aye.
All opposed? Right, we'll mark that as unanimous. The only public hearing on the agenda tonight is the continuing hearing in Appeal 2020-002 relating to the certification by the Director of Planning and Zoning of adequate public facilities for the project known as the Lofts at Eastport Landing. The board has received and reviewed a number of public comments. We thank those commentators for their comments and their civic engagement. And the comments will be marked and entered into the record. As a result of legislated changes in the standard of review, we have a restated notice of appeal from Ms. Halleck on behalf of the appellants, and we have a restated designation of the record by Mr. Braithwaite on behalf of the city. Thank you for your hard work and your cooperation with the other parties in making that happen. Mr. Braithwaite has generously acceded to requests from counsel for appellants to add additional materials to the record, consisting largely of evidence submitted during the earlier hearings in the previous appeal. Ms. Halleck presses by motion that additional evidence should also be included in the record. So we'll take up that issue first. Ms. Halleck, first let me remind you, I think in the last pleading I saw from you, you said you were submitting on behalf of appellants and Mr. Rogers pro se. As you'll recall, Mr. Rogers is no longer appearing in this case pro se. I asked Ms. Rouse to reject anything else for filing that says it's on behalf of Mr. Rogers pro se. So, Ms. Halleck, I believe you misunderstand the concept of the record in this case. The record in appeal on the record is what the city says it is. Now, the city has welcomed your suggestions and added some things that have caused a separate controversy. And if you have things you think the board needs to consider that are not in the record designated by the city, you have the opportunity to ask the board for an exception to the general rule that evidence outside the record should be admitted. Otherwise, the record is what the city says it is. Appellants have no right to add to the record. So the motion in that regard is denied. Mr. Hyatt contends that Mr. Braithwaite has been too generous in acceding to Ms. Halleck's request for additions to the record. While the city does designate the record, I don't see how evidence relating to the 4 facilities that the board has already found to be adequate should be part of the record, since that's has nothing to do with this appeal. So to the extent Mr. Braithwaite has added to the record exhibits that bear exclusively on those issues, we don't want those in the record. And I'll leave it this way, that the items highlighted by Mr. Hyatt in the attachment to his motion, highlighted in yellow, will be stricken from the record, subject to giving Ms. Halleck an opportunity to show why any one of those in particular should appropriately be included in the record. Ms. Halleck also objects to certain written witness statements, which may or may not have been offered by Mr. Braithwaite. I remember we talked about this at the earlier hearing, but I haven't seen them. Have any of the other members of the board seen these written witness statements? No? All right. Mr. Braithwaite, can you fill us in on where we are on that score?
Joe Albright on behalf of the city. The city had previously prepared written witness statements to allow the board to stick within the 2.5 hours that it's set for hearing of this appeal. And we thought it best that appellants be apprised of what our city's testimony was going to be should witnesses be called. Because this hearing is on the record and we can't present no witnesses, I do believe that the testimony contained therein should be stricken because there are no witnesses and no one is allowed witnesses. And that's why I was somewhat surprised by the motion, because the city did not designate its witness testimony in any part of the record. And so I'm not sure if this motion is moot only because the city never attempted to designate the witness testimony as a part of the record.
Yeah, thank you. It is moot. I think
If-
that
I see it in the record.
it's not in the record. If it was in there, it's just been stricken. So we don't need to waste any more time on
Fair
it.
enough.
It might have been helpful. I think it probably would have been helpful, but I understand where we are and that's where we are. So now we're going to get to the argument.
Mr. Chair,
Chairman?
Yeah.
If I may address the board,
hang
I
on
am-
1 second, Ms. Halleck. Michael Walsh is in the waiting room. He's asking to be let in. So he's here.
Oh,
Oh, I'm
Thank
sorry. If I could
Brad.
clarify that.
Ryan, you'll let him in.
Yes, he is a panelist. He was having issues with his camera. He was letting you know that he is going to close Zoom and then restart it. So he might be missing for a few seconds.
Okay. All right. So we know that he's there and we'll let him in as soon as we can get him in. Ms. Halleck?
yeah, I understand that the issue is, you've ruled on the issue of the record in this case, but I want to make sure that there are other parts to it as well, that I have designated exhibits to be admitted into the record, not necessarily amending the record as it's designated, but exhibits for the purposes of this hearing. Now, I want to cite the code site, why I understand that this is appropriate. That number one, the language for the code site has not been changed with the new standards. And that at the meetings, the board is to consider any testimony and evidence from the applicants. And that's in section 2010-040. All meetings of the board shall be open to the public and relevant testimony and evidence accepted from all interested parties. Now, that's evidence. It may not be for the record, designating the record before, but that's evidence. For example, those are exhibits that I designated and submitted. Now, for
Ms.
example,
Halleck, you've argued this before. We've ruled on it before. The rule is if you think there is evidence outside the record that you need to offer, at the appropriate time, you will tell us what it is and why it merits an exception to the general rule that an appeal on the record is on the record. So when we get to that point, you'll have your opportunity to make that argument. We're not going to make any blanket rulings that you can offer up any exhibits or testimony that you want to. Is that understood?
I just want to object here to the record because first of all, I understand that making this rule is a very strict rule and narrowing it. I want to make my objection on the record here to say that this board is a quasi judicial board, that this is not the Court of Appeals, that the purposes of a public hearing are to provide the testimony and evidence that is relevant to the court, to the body, the board here. And one of the important matters here is that this is the same appeal, the same project. No new application was submitted. that the issues before the board are the same issues that were presented before, and this board is making decisions based on that. Secondly, importantly, this board directed, this is a remand, which is different from any other previous matters. And the board directed the city to consider, to reevaluate this application and to consider the concerns and evidence presented at the prior hearing. And for the city, they were instructed to consider this information. And now what's designated is not the information that they were to consider. The record is supposed to be the information considered by the city in making its decisions.
Ms. Halleck, we've
And-
ruled on this. That's enough. This is the third or fourth time you've argued this. The ruling is clear. You can't tell us what the city considered. The city tells us what they considered. You can tell us what they should have considered that they didn't. You can tell us why what they said they considered shouldn't have been considered, but you can't tell us what they considered. So that's enough. Am I understood?
I needed to make a record. I thank you very much.
You've made your record several times. All right. I propose, although I think it'll take longer, I think it'll be helpful in the long run, that as for the argument, I suggest, and I'm welcome anyone's comments, that we go facility by facility. I think it'll be a clearer way to do that. Any comments from my colleagues on the board? Are we good with that? So here's the way it's going to go. As we said before, the order is going to be city, appellants, applicants. Members of the board, you can interrupt to ask questions anytime you like, but board members will also have the opportunity to ask questions at the end of the segment on each facility and of course at the end of the arguments. So if you need to interrupt. If you don't, wait until the end of the segment. I'd ask counsel for the parties to keep the arguments as short as possible. We're familiar with the subject. We've read everything that's been submitted, and to keep your initial arguments under 10 minutes. Confine your recitation of facts to the facts that are in the record. Or if you think you have an exception to the record, tell us about that. So Mr. Braithwaite will start out telling us why the determinations on remand are supported by the record under the new standard review. Ms. Halleck will be next telling us why they are not. And Mr. Hyatt will play cleanup there. Please be mindful of the new standard of review. The board no longer decides what is the most appropriate outcome. The experts do that. And then we merely decide whether a reasonable person could have reached the same conclusion as the director based on the evidence in the record. So with that, let me ask Mr. Braithwaite to start. And the order I thought we would use would be police, recreation, traffic, non-traffic, and stormwater. So if Mr. Braithwaite would like to begin, that would be great.
May it please the court. My name is Joel Braithwaite, and I have the pleasure today of representing the city of Annapolis. Here we are called upon to discuss whether and under what conditions this application can be allowed to move forward after the city has found that there are in fact adequate public facilities. Now, what is important for the board to understand is that in on remand as to every adequate public facility that was remanded, we ultimately agreed with the board. Ultimately, we found that each subject on remand was insufficient and inadequate. And as a result, we entered into mitigation plans as to each facility. So there are two things here. We know that appellant is not appealing our finding of inadequacy. So because they're not appealing our findings of inadequacy and arguing that we were wrong and therefore these facilities should have been found adequate, the real discussion goes to the only thing that can be attacked, which is the mitigation plan. The mitigation plan is a mandatory part of the law. The mitigation plan requires that the city engage in conversations with the applicant and come to a reasonable solution. In our process to come to our solutions, we engaged in many mediative and negotiations, discussions, and it took several weeks of hard-fought concessions on both sides to come to an agreement, while that which may not be perfect, but it represents the best for the people of Annapolis as well as for the applicant. So the city is in the position where we must balance both competing concerns. With respect to the adequacy, or rather the inadequacy of our police protection services, Ms. Halleck's motion points out all the issues in which we would probably agree with as facts as to why the public facility, or rather our police protection facility is inadequate. But police protection can only be solved by an increase in the budget. So as Ms. Halleck pointed out in her motion, it's not all the police officers in the budget that count. It's only the qualified police officers, and it's not the qualified police officers that the city employs, but only those that serves in the police department. So the issue we have is that we have around 110 sworn officers. At 110 sworn officers, we would need an additional 30 officers, 20 officers, but there's a number of officers that we need, but that is a budget concern, and the budget is not going to get any better with COVID. So we are in a position where we cannot approve as adequate police service absent a mitigation plan. Here is the mitigation plan that we chose today. The mitigation plan, after much discussion, we and especially engaging the chief of police. The chief of police agreed with applicants after much discussion that a minimum of 10 high definition 4K cameras will be placed throughout the project, and that the access to the cameras will be provided to the police department by the applicant upon request. Now, the biggest part of the negotiation was the commitment by applicant to commit an annual budget of $50,000 to pay for off-duty police officers to be employed on the site. Now, we had a discussion as to whether we should ask the applicant to give us $125,000, for example, annually for one FTE. But the problem that you encounter there is that the code section for mitigation requires that it must be roughly proportionate to the brief indulgence. I'll actually have the words. So it must be roughly proportionate to the impact on the development. So as to every public facility that we discussed in our mitigation plan, there's only one question for the board. Is our mitigation plan roughly proportionate to the impact? That's the only question for the board, because while the board had, there's actually three questions that you ask yourself before getting the mitigation. First is, are facilities adequate? We are saying that none of the facilities on remand are adequate. Second, is the mitigation plan roughly proportionate? And third, was it done in consultation with each of the directors that the code requires? So because every director that the code required signed the agreement, you know that it was done in consultation with the director. Because we found every facility inadequate, you know that then the only question is whether our mitigation plan is roughly proportionate. So why can the city not impose upon the applicant and ask the applicant to pay, let's say $125,000 to pay for one FTE? The rough proportionate, the direct proportion of what this development will add to our facilities, for example, it's not that we need a police officer there 24 hours a day. The only place that police officers need to be 24 hours a day is our police department. We want police officers patrolling the community, doing the things that they do. We don't intend to create a police substation there, and we're not asking the applicant pay for an FTE in that regard. The other thing you have to look at, as the police chief has discussed with me and of course with the director, is that you must look at what is the burden that this type of development will bring to the city with respect to police protection. And what the police chief said in his great discretion, and you understand that he's the chief of police. The chief of police has certain credentials and expertise that we have to rely on in making his decisions. Among the things, our chief of police is one of the most learned chiefs of police in America because he's actually also a professor. And what he said in his expert opinion would be adequate. It's a high definition camera system. And if they provide for $50,000 annually, and here's how we calculated the $50,000. The $50,000, if you look at a fully loaded FTE is $125,000, we estimated that most of the time police service would not be required for 16 hours of the day, for example. So if you scale that number down to roughly a third, you'll get to the idea that there's a number somewhere around there of how much police service might a development like this require on a daily basis. Applicant and the city, after much discussion, were able to agree that $50,000 an annual budget of $50,000 so that off-duty city police officers may be there as kind of like uniformed type security. We thought that that was the best approach for the city because we didn't want to load the applicant up with paying for a full FTE because the full FTE, you must remember, services all of the city of Annapolis. So we can't say to the applicant that your development will burden the entire city of Annapolis to the point where we need an entire FTE. We need more FTEs and there's no question about it. But the way we must get FTEs is we must get it through the budget. We cannot look to this one applicant to solve all the problems. And what we said is a reasonable estimate of what police power may be required is that $50,000 budget. Now, there have been arguments that applicants can, not in good faith, say, hey, I hired one officer for $10 and I'm not gonna spend my allocated budget. The issue with that is that there are other parts of our city code that require that if you're a development kind of like an apartment building and you get a certain amount of police calls, at some point, it becomes an issue where we start looking at development. So it's not in development's best interest to not live up to their portion of the deal. So with that in mind, I'll close by saying, because we cannot get to, in this budget, the 3.2 budgeted officers for every 1,000 city residents, this facilities are inadequate, and our chief of police being actively involved in negotiations and for consultation has agreed that $50,000 plus the high definition cameras would give him the requisite level of comfort to know that the public in that development and in that area and in the city of Annapolis will be properly provided for. With that, I'll close.
Thank you, Mr. Braithwaite. Ms. Halleck.
Ms. Halleck, you're on mute.
You're on mute.
I'm going to start with the introduction here is that the board's final decision on March 17th, 2020 had three major findings. The city failed to publish adequate or updated standards for APF determinations. The APF reports from the department heads were perfunctory and did not provide analysis or reasoning behind the approvals. Mr. Braithwaite, you've just provided much more detail and analysis that it's not in your report, and that's kind of a problem that we're dealing with here. And three, as a matter of law and fact, 5 out of the 9 required public facilities were inadequate. The board didn't simply find that the city failed to publish proper standards and provide substantive reports, parts 1 and 2. It specifically and definitively ruled that the 5 facilities were inadequate. The board remanded it with instructions to update and expand the standards, issue reports that are actual findings and analysis and not just conclusions. That's been the problem. That's the problem. You're just done a great analysis, but your department just had a conclusion and no report on that. And to address and correct the deficiencies identified and articulated at the hearing and identified the board in its deliberation, analysis, and decision. And it's clear that the city didn't apprehend or implement the board's directive. Page 1 of the certificate of adequacy, or more precisely, it should be certificate of inadequacy. Director Nash wrote that the adequacy of 4 out of the 5 areas was confirmed. However, she writes, the board found the previous 5 areas are in need of reevaluation. That's it. It doesn't say that it's inadequate, just need to be looked at again. She didn't acknowledge that the 5 facilities with the conditions as included in the city reports and certification were ruled to be inadequate. And the board noted after one of the board members articulated a concern, it was reluctant to do a general remand on just the first two procedural deficiency because it didn't want the city to publish the standards and then essentially affirm the project without addressing the inadequacies presented at the hearing. The chairman explained that it was sending it back, and I do these quotes, sending it back with specific reference to the issues presented and giving the applicant and the city, quote unquote, a redo, and it will give them another chance to get it right. The board directed the applicants and the city to go back to the drawing board and rework this project and correct the problems and conditions presented at the hearing and as identified by the board. But that didn't happen. No new plan or revised drawings were submitted by the applicant. Instead, the same plan was reevaluated and the determination made that the project is submitted without corrective conditions to the 5 APL areas was inadequate and could proceed through mitigation. So the first hearing was done over 7 hearings as to the adequacy standards. And this review, I agree, is on the mitigation standards and whether the city both published and applied the minimum legal standard and requirements for mitigation. The legal code, the standard for mitigation mitigation consists of the construction or funding of improvements, both on-site and off-site, for public facilities that increase the capacity or safety on each public facility that is below the minimum standard so that the capacity or safety of the facility after mitigation will be equal to or greater if the proposed project had not been developed. And that's the standard. So it's equal to or greater than if the project had not been developed. This primary legal standard, the applicant and the city must achieve to make the mitigation plan sufficient as a matter of law and fact. And where the director fails to require the applicant to meet this legal standards, it's an abuse of discretion and arbitrary and capricious. A careful review of the mitigation plan requirements for each of the 5 facilities shows that the conditions required and agreed to by the city and the applicant fail to make the facilities adequate under the required mitigation standards. And since you jumped to police, I'm going to go ahead and jump to the police here. And importantly, you got to put it in context. Let's start with the goals of the code here. The APF general goal is to assure that the proposed development protects the health and safety, public health and safety, promotes the general welfare of the community, and conserves the environment. And the police goal is to ensure that the law and order is maintained, the laws of the city of Annapolis are enforced, and importantly, to create and sustain an environment of personal safety and security of property among citizens, business persons, and visitors. Police officer means an individual who's certified by the Maryland Police and Training Standards Commission and employed by the police department. So just off the top, that does not therefore include the chief of police because he's not certified by the Maryland Police and Training Standards Commission. So the number of officers is not 124, it's down lower, it's 123. And that the officer ratio, and this is important, the ratio of police officers authorized in the current budget to city residents shall be not less than 3.2 officers per every 1,000 city residents. If you add 237 residents of this unit and 3.2 officers for every city resident, that means that roughly, if you look at the numbers, that for every 312 residents you add, you need to add an officer. And so when to say, we'll address that. The board found in its final order that the facility was inadequate because the city's own calculation, the numbers of officers, was not 3.2 as required. The board found the city's calculation of residents at the prior hearing was improperly done using 2010 census and not calculating the number of new residents. In response to the remand, the city added standards to allow the use of US Census Bureau estimates for the population and average people in Annapolis. It also used the average number of people per household, 3.2. Then using this estimated population number, the city APF report concluded that the facility is inadequate and must proceed by mitigation because 126 officers were needed and only 123 were authorized. Then the mitigation plan only included 2 items. install security cameras, 10 security cameras with access to the cameras. It's not clear what they mean by access to the cameras themselves or to the recordings upon request by the police department. Commit up to, not commit 50,000, but commit up to 50,000 annually for off-duty police officers to be employed on site with an understanding that if off-duty officers are not available, they may use private security. Now that's a big difference too. That's not, we're asking you to provide an officer on site. This is security officer now with until the 3.2 residence is satisfied. The city's adequacy report and mitigation plan are factually and legally defective for many reasons. Number one, for the resident component of the project, the calculation of the number of officers needed for the project is 127 and not 126. Where the requirement for officers is 3.2 per 1,000 residents, the ratio under the city's calculation came out to 126.1. And we know you can't just round down an officer. You have to meet the minimum standard of 3.2. So it's 127. And that's important to understand. What's lacking here on this facility? If you had to have 127 and you've got far less, that's important to know. The project is mixed residential and commercial retail, and the city only calculated the residential needs. It failed to address the adequacy for the commercial and retail. In addition to the number of residents added for this project, there will be 14,535 feet of commercial and retail space, including a restaurant. This will add a significant number of persons to the area, including parking, walking, and driving, who will require police services, both on site and off, in addition to the residents of the unit. The consideration of additional police resources for commercial and retail space and activities was omitted in the APF report from the city and was not considered or addressed in both the calculation of adequacy or the analysis of the mitigation requirements. In 2018 and now in 2020, the actual number of officers hired by the city and authorized in the budget is closer to 113 and 100 to 115. The city has never hired the 123 officers it authorized over 10 years ago, and instead used the money budgeted for these unhired officers to pay other police department expenses. The city council's passed an ordinance recently which froze the hiring of these unfilled officer positions, making them formally unauthorized in the budget and not hired by the city as required by the code. The city is actually short 10 to 13 officers. That's almost 10% of its staff. The significant shortfall was omitted in the APF report and the city is not considered or addressed both the calculation of adequacy or, more importantly, these numbers in the analysis of mitigation. Now, the most egregious flaw, this I included both the introduction and the police. So I'm at 5 minutes for the introduction. I'm just going to read through this quickly. The most egregious flaw in the police mitigation plan that it does not actually require any city or security officers to be hired or provided on site. The plan states that they must commit up to 50,000 and not a minimum of 50,000. The application of this means that they can meet mitigation by spending 5,000 or even $1. Think about this. The primary element of their mitigation plan is not a requirement at all. It's merely a suggestion. The mitigation plan was poorly drafted and not thought out, and by fact and law does not meet the requirements of mitigation. In addition to that critical flaw, there's no requirement as to what time of the day or days of the week the security officers must be on duty. Weekends and evenings are the critical time, and there's nothing there. The use of off-duty officers is unrealistic because the city's so short of officers, they're already covering the overtime shifts and they're not there. There's so few of them. HACA stopped using them, just don't have them. They're tired after their shift and they're sleeping in their cars. The requirement to add security cameras is not meaningful because cameras are already a standard feature in larger commercial and residential buildings. They're already required. It gives the appearance of adding security, but it's not really anything in effect. It's like saying, I need you to put more lights in this out on the already well-lit parking space, or I need a key code. It really isn't anything that's added. It's something that's standard for an apartment building and a restaurant. So there's really no additional security here. There's no requirement that a video monitoring site with a security officer on duty to actually watch it. On-site security cameras will simply record it, and then they'll send it over to the police department if there's any problem, for the police department that's already 10% shy. Requiring the cameras to be installed serves little to assist here and will increase the workload of the police department. And providing cameras and a security guard does not replace the off-site police protection that additional residents, their guests, and customers require, such as traffic enforcement, accident response, going to court, crime investigations, communications, 911, calling, fingerprinting, investigations, car thefts and break-in, especially for boats and whatnot that are down in the marinas for all these new residents, insurance loss, police reports, personal property loss, theft and damage, and for all of those residents walking down to bars and walking their dogs over in the hotspots of our neighborhood, that's not provided. Security officers cannot provide this. The Watergate have residents report frequent break-ins and tire rim thefts in the surrounding public streets. Security cameras and private security officers are not going to provide security and address that issue, especially when the city department is already 10% shy. It's abundantly clear that for all the reasons stated, the mitigation plan is factually and legally sufficient because the capacity of the police department facilities under the plan will not be equal or greater than if this project had not been developed. And if you want to work on looking at mitigation, on what it is and what the percentage is, if you take the number of residents for this place and you add the retail, it is one full officer. So this mitigation fails as a matter of fact and law. Sorry for the extra time. Thank you.
Thank you. Thank you. Mr. Hyatt. You have to unmute yourself. There you go.
Yep. Thank you, Mr. Chairman. Good evening. I'm Alan Hyatt. I represent the applicants here tonight, and thank you for the opportunity to be heard. The one point that Ms. Halleck overlooked is that retail is simply being replaced. There's no new retail. Retail is there already. It's being replaced, and that's what we're talking about here. Is what's new is the 98 residential units. That's the new feature here. So when this board determined that it would remand the matter back to the Department of Planning and Zoning, it stated that the population calculated from 2010 or from the 2010 census without any adjustment was not appropriate. You may recall that. So what did the police department do after being directed to cure that? Well, they determined in its standards that it must utilize the most up-to-date data publication available to determine the population of the city. And that's what they did. They concluded that the population was 39,408. Under 22.14 of all of the criteria, we have a fairly straightforward formulaic calculation. One concerns the response time, and that was satisfied. That was clearly resolved. There's adequate response time. It meets the criteria set forth in the code, so check that box, that's fine. Where adequacy was not satisfied is in the calculation requiring 3.2 budgeted police officers per 1,000 of the population. The 1,000, or the population, I should say, was properly calculated by the police department. And what they concluded was that there was 3.121 officers per 1,000. That is a difference of 0.079, or about 2.47%. So when you're shy 2.47% in a shopping center that's been around for a long time, that's adding 98 apartments, what do? Well, when you're the police chief, you consider the circumstances of what's going to be at the site, how short you are on police officers, and you're pretty darn close at 3.121. And the determination was made by the police chief in discussion with the Department of Planning and Zoning that there would be the 10 high definition 4K cameras throughout the project, and then a commitment for up to $50,000 annually. That was a determination made by the expert, by the police chief. And what you have here, and you certainly alluded to it in the opening, is an appeal on the record. That means that this board doesn't substitute its judgment for that of the police chief, unless the police chief acted in some arbitrary fashion and didn't act based upon the circumstances before him in a way that a reasoning mind couldn't come up with this reasonable conclusion. Then even if you disagree with the police chief, you have to let his decision stand. And try as the appellants may, everything is a matter of fact and a matter of law. It's arbitrary. Well, it's not. The reality is you have the expert making the decision. 22.28 guides the city in terms of mitigation. So you have very, very slight inadequacy. It's a matter of degree. And the decision made based upon the correct calculation of the population. And this is what the experts relied upon in the city. The police chief made that determination. And the appellants clearly have the burden of proof. There's nothing in the record whatsoever to support that this decision was arbitrary and incorrect. And for that reason, it must stand. Thank you.
Thank you, Mr. Hyatt. Do we have any questions from any of the counsel for the parties? Michael?
Thank you, Mr. Chairman. I hope Tammy noticed that I am present. I was trying to work through some technical issues when the roll call was taken. So if Ms. Hook would indicate that in the record, I'd appreciate it. A question I have for Mr. Braithwaite on some of his comments and generally about the mitigation plan in total. Mr. Braithwaite, as I read 2214-040, it says, 2214-030, there are no exemptions for any projects to the police, adequate police protection that's required. And that goes on to issue that, to mention the two standards that are being discussed right now about the officer ratio and the response times. Out of curiosity, how did the city come to a mitigation agreement that is not consistent with the code? I mean, is there a similar condition where mitigations have more or less suspended the requirements of 2214-040, or is that just something you're going to do in the interim until the police department is up to the certain ratio?
So Joel Braithwaite on behalf of the Office of Law, thank you for your question. I would say that there are two things here. In your question, you ask so there's the requirement that we must have these officers in the budget. So this is a budget question, right? Mm-hmm. It's the number of officers in the budget. If our budget is created by annual tax levy, if there's not enough funds in our annual tax levy to pay for the budgeted slots, as a matter of law, not as a matter of law, but the math is really simple. Even if you put us at 40,000 and you put our officers at 125 officers, we will not have enough, even if we increased it by 13 officers. So now the law says there's no exception, but then the law says for every APF that is going to fail, every APF that we find inadequate, there must be mitigation. There shall be mitigation. So the law, in saying that there's no exceptions, also created a mitigation, and the mitigation plan says must. So I do not read these things as conflict. I think that what it says is that to the extent that you cannot pass APF, it requires, no exceptions requires that you fail APF. We have failed them on the APF. Now the law then requires that the applicant must be given an opportunity to mitigate. And in this instance, the applicant and the city were able to come to terms. Note that if the city was not able to come to terms, the final finding that there is no, that the facility is inadequate would have ended the conversation because of there would be no mitigation plan. And then it just is a rejection because we don't have the appropriate facilities. So have I answered your question?
To an extent, I mean, certainly you've answered it. I still, I guess I reasonably could interpret it differently, which would be that the no exception language is pretty clear, and that the mitigation language comes down to an assessment of whether the facilities fail on their face, as opposed to, okay, they fail, so let's mitigate the failure, because there's no exceptions according to the code.
So you can't read the code in a way that conflicts with itself. That's one of the standards of construction. So if you were to read it like that, then you'll give no effect to us having a mitigation section, because the exception, when it says no exceptions, there's no exception. So there is not a way that the police chief can say, while this fails, we will accept this and pass it anyway. That is not what the police chief does not have the authority to provide an exception to the general rule that if we do not meet the 3.26 or rather the 3.2, that it must fail. So it has failed. So that's why applicants, or not applicants, rather appellants' arguments about the correctness of our math really matters not, because there's no math that will allow this to have this facility in particular to be adequate. So we have conceded the point. Now, if you read it that there are no exceptions, meaning that you can't go to mitigation, then why did the city council write a mitigation section? The city council, in writing a mitigation section, required that every facility that was going to be failed, we must offer the opportunity to mitigate. And so I cannot read the city code as being in conflict with itself such that it says no exceptions, therefore no mitigation. It's no exceptions. That means you must fail. We have failed them. Now they must also present an opportunity to mitigate. And in that opportunity to mitigate, we were able to reach an agreement.
If I can move on, to your knowledge, is there a similar mitigation plan for any other projects, or one that might be pending? I mean, is this a new practice, or?
No, I would say it's the law. We are following the law. It's not about our practice. We don't have a choice in allowing mitigation. We don't have a choice in failing.
It is the law, but the substance of your mitigation proposal, of the city's mitigation proposal, strikes me as kind of a workaround. And I think that's a fair statement, don't you?
No, I don't. And the reason I don't agree with the statement is because there's no exception. So you have to read. So there are two statutes of statutory construction that are conflicting from your argument. The first statute is that you must read the entire code section together. The entire chapter must be read together. The second thing is you must assume that the city council never intended to be superfluous. That means they never intended to create a mitigation section if they didn't intend that the mitigation section be actually used. So the combination of them saying no exceptions and telling you that they must fail, and then saying that they must also have access to mitigation, that's what we must do. You can't construe it as it's not a workaround, because the workaround would be an exception. There's no exception. So they have failed. It's not that they failed to meet the standard and we said, okay, no harm, no foul, you can still move forward. It is then what happens next, mitigation. And so the question that I think that the board should be focused on, and it actually goes to two parts of the mitigation code. It's the one that appellants have focused on, where they said the mitigation must be equal to or greater than the proposed project had it not been developed. And then it's also the part that it must be roughly proportionate. That's a constitutional requirement, I'll be at. Mm-hmm. We cannot disproportionately burden the applicant with fixing the city's budget problem. We can't go to the applicant and say, we are 13 officers short. We need 125,000 times 13. What we have to do is a different math. We have to say, what is the increased burden that you're going to place on the public facilities? And what can we do to mitigate that burden? And so while appellant stated differently, by focusing on mitigation will be equal to or greater than the proposed, if the proposed project had not been developed, correct? And that is correct. The real constitutional limit is roughly proportionate. So the question the question before the board is whether this is roughly proportionate. As applicant argued that it's a 2% makeup. And the other thing that you're laying under, it's the discretion of the city police, not the city police, but the chief of police. Our police chief is one of the most learned police chiefs anywhere. He is literally a scholar. He is a professor. He teaches law. And these were part of the great credentials that led to him being hired in the city of Annapolis. So it is also his judgment that must weigh, and his judgment is entitled to deference.
Michael, do you have more?
I'll let the others go by.
Christian?
Back.
I hope I was helpful, Mr. Wash.
Thank
Very
you.
Very quickly, is it your similar interpretation of the up to $50,000? Did you hear that the same way, that $1 would satisfy the up to portion of that mitigation
No.
plan?
So the reason that language was put into the agreement was because applicants were looking for a cap on, and it was a proportionate cap. What it is that, again, we couldn't go to them and ask them for the entire FTE. Did we want to ask them for the entire FTE? Yes. But in asking them for the entire FTE, we would have overburdened them in proportion to the, not risk, but we are just mitigating the risk that they bring. And when I say risk, I'm talking about risk because we're talking about police protection.
So the way I understand it is that, so who has authority to spend that $50,000 discretionary fund? Is it something the city would order? Is it something that the developer would put a plan together for year one and show you how they would spend $50,000 and then reduce it down? How does that up to get managed?
You've asked a great question, and I believe that at this point, there's not even a development in sight. I think that what we have here, this is about adequate public facilities. This is whether we can support adding the development. And what the discussion is and what the mitigation plans are is just to get the project to the next stage. I will say if I could briefly say two things. This represents the first successful appeal of APF, not in American history, but probably close throughout the nation. And the reason that this adequate public facilities is not a right place for appeals is because who has the ability to tell you if their facilities are adequate? The government does. And who has the ability to tell us what it takes to make those facilities adequate? The government does. But unlike other people with just expertise, we have to do this for the public. We are public officials. We are executing the public trust, and we cannot act in a way that does not benefit the public, meaning all the citizens of Annapolis. So that is our call, and our best efforts to do that is we met with the applicant, we negotiated after several rounds, and we found an agreement that both parties could live with, and that's the agreement that stands before you today.
And where in the arc of this potential project, from where we are today to fully operational and fully occupied, do you think the appropriate spot for this mitigation to drill down on the detail of the mitigation plan happens?
So I believe that the commitment is there. They have committed up to 50,000, and the 50,000 was imposed as a cap by the applicant so that the applicant would have a cap. The 50,000, the chief of police in his determination, he looked at it, he said, well, look, most places like this will only need police service for probably 4 to 6 hours a day from his professional opinion. And that's why he was able to give the cap of at or around 50,000.
Yeah, counsel, I acknowledge that the determination is mutually agreed by applicant and police chief, but what I'm asking is who at the city from this point on manages or takes responsibility to execute that spend?
I believe that there are organizations within the police department that are going to be very interested in holding applicants' foot to the fire about this. There are organizations within the police department comprised of police officers.
Maybe I'll redirect my question. Dr. Nash, during the
Thank
planning, permit planning and review process, is there an appropriate foothold for this discussion to take place? Where does this happen?
Sally, you're on mute.
Yes, we typically do documents like this in the grading permit process. So before we would issue a grading permit, we would have all those kinds of documents and MOUs, contracts signed. That's when we do the stormwater management agreement. That's when we do an MPDU agreement, if applicable. And that's when I would want to make sure that these agreements were in place and the money was going to the appropriate account.
And the city has the appropriate, I don't want to say, I was just say the authority and auditing capabilities and personnel and all of that to say the call for services was at this level, but you only spent 34,000. So now next year I want you to spend 16,000 more, and we're going to see a linear relationship between calls for service and dollars spent. That seems like an enormous, that's a whole nother department for one shopping center. And I realize that I'm just playing the devil's advocate here. I want to hear all sides. I'm not trying to put anybody on the spot, but I am, and I hear Mr. Braithwaite's Joel's argument position that the police themselves in this regard, right? They are them and only them are qualified to say what's adequate. There's nobody else on this. How many of those are there? 21 participants who can say what's adequate. The code says what's adequate. It's a ratio, right? But short of that, we defer. It tells us to defer to the expert. I guess that's where I am. But I don't love the response that, because, I draw a conclusion like that when we get down to section 2, REX, there is a pay in lieu of service, fee in lieu of qualifying position, right? This is bordering very close to fee in lieu of meeting the requirement. But yet we don't have the resources, mechanisms, facilities in place to take 50 grand or see 50 grand get spent. That concerns me a little bit. I don't know that the 50 grand is necessary. I don't know that $1 is necessary. I know that the chief of police and the applicant had agreed that they're willing to spend 50 grand, and the chief of police thought that that was probably a good number, but it comes really short of a plan.
Okay.
That's it. That's all I got to say.
Anyone else on the board have questions?
I do, Mr. Chairman. Mr. Braithwaite, I got as a follow-up to Mr. Zazali's comments, I really need to drill down into your comments with regard to the mitigation plan. When the chief of police says you need 4 to 6 hours per day of policing, and he feels that $50,000 will cover the manpower for those 4 to 6 hours. Why in the mitigation plan is there not a requirement? Why is there the language of up to 50,000? What was the police chief agreeing to? I think you're on mute.
No.
No? Uh-oh.
Joel, we're not hearing you.
Can't hear you. Sorry.
Ryan, can you be of any assistance here?
Yeah, unfortunately, it's showing him not muted, but we aren't able to hear him. Joel, there's a little triangle next to the mute and unmute button. and that will let you select your microphone. Maybe something has changed there.
Hello, can everyone hear me now?
Yes,
Yes.
Okay,
Great.
thank you.
thanks, Ryan.
So the $10,000 is a cap. The $50,000 is a cap, and the cap was at the request of the applicant so that they know that the expenses wouldn't exceed that budget. Basically, in running so in their annual budget, they will have a $50,000 item, whether the item is called security or whatever the case may be, that they have to spend down, and that will be a part of their kind of internal documents that they would have to manage the different budget or whatever the case may be. The one thing that we must all be aware of is I don't know if in Annapolis it's called a PBA, Police Benevolent Association, or the union, or the union is who is going to be interested in enforcing this part of the deal. They're going to be self-interested in making sure that their officers have access to this particular budget. The 4 to 6 hours a day, it's because the police chief looked at when police services required and looked at what are the high times for calls for service. And then that's when, so there's not no crime at 8 o'clock in the morning, but from 8 to 4, chances are it's not necessarily a high crime time. And that's just probably nationally, right? So that's why the focus is there to have someone, so at or around the area, more for evening hours is kind of the essence of what the thinking was.
So are you saying then that the police union will be the watchdog for the safety of the citizens that live in and around this new development? And that
No.
the union will be responsible for going to whomever they go to for the $50,000?
No, that's not what I'm saying.
Who is going to enforce this?
I am
Because
saying,
you mentioned before in your presentation about the police being incentivized, that 50,000 gets spent as opposed to $1. So that's my first question with regard to your mentioning the union. But really, I'm trying to drill down into what exactly the police chief agreed to.
the agreement has,
It could be $1, as has been mentioned previously. But he thinks we need 4 to 6 hours of coverage. So it can't be $1. So why doesn't the mitigation plan clearly state in black and white what is required, not up to $50,000?
so I think what we're getting into now is a great discussion, and the discussion actually highlights the standard of review. We are having, reasonable minds are having a discussion about what should the appropriate term be. And because reasonable minds are able to have this conversation about, well, how do we ensure that the $50,000 is spent? And reasonable minds are further able to say, well, okay, so if $50,000 is a good number, and the $50,000, again, that's a set aside for only City of Annapolis police officers, because there's a point of discussion where that could have said police officers in Anne Arundel County to increase the pool of officers who may be authorized to provide this service. So again, this is an agreement that the City of Annapolis Police will benefit from having access to this work. And I'm not sure that within the standard of review, that some of the questions that we're asking might be getting far afield from what the call is. The call is, we understand that the facility is inadequate. What we are trying to do is determine whether this is not an arbitrary and capricious agreement. And so to the extent that we can continue to have the conversation, I believe that it kind of shows that there may be other things that people can consider or could consider, but this is what we did consider. And then the question to you comes whether this is arbitrary and capricious.
All right, Nadine, anything else?
Thank you.
Andrew's up.
Andrew, please.
I know we've spent some time on this topic, but my question's pretty direct. How much does it cost to have a City of Annapolis police officer on duty working secondary for 6 hours a day, 365 days a year? I literally have no idea. Is that something that can be achieved within a $50,000 budget, or is that $150,000?
You ask a great question. Unfortunately, there's a calculator for that. Basically, what you would do, you will take the 125 FTE and then you actually divide 60 by the 125 and you come up with a ratio. The ratio is 0.48. So with the $50,000, let me actually make sure I do that again. It's $50,000 divided by 125. Okay, that's better, 0.4. So what we're saying is that in an average day, the police chief believes that there are only certain high times when there's even a potential for a call to service to that area, right? If we have someone on hand, that person can immediately respond. And and the other thing you must understand, the payment of the FTE for the off-duty police officer benefits the entirety of Eastport, because during those hours, if you have someone stationed at or around Eastport Lofts, they're able to respond to any police emergency within Ward 8 or even into Ward 1 immediately. So the payment is not for a police to sit and just be there, and it is police service that the public benefits from. The police doesn't sit there and say, well, I'm not concerned with crime in the city of Annapolis. He is exactly concerned with crime in the city of Annapolis. So that's my suggestion about it. And that's how you would get it. You would look at it's 0.4. So we're arguing that of a 24-hour day, of 40% of that day needs coverage. And that's where this number represents 40% of an FTE. So Mr. Burnett, does that accurately answer your question?
I think you answered my question, but now I may have confused myself because I thought what we were, so sorry, everybody, for my own confusion. Maybe it's the late hour. I thought
$27 an hour, Andrew.
Yeah, well, I mean, that's what I'm going at, Christian, is are we saying that this is going to be office? Because you keep, Mr. Braithwaite, you're hinting at that whether it's the union or the whoever that has the interest. In other words, there's going to be an interest in officers having secondary employment that they wouldn't otherwise get. So they have an interest in making sure that $50,000 is spent. And what I'm trying to understand is if that money is going to be spent on second officers working secondary, is that enough to cover, is $50,000 enough to cover that 4 to 6 hours that could potentially be needed? And the reason I ask that is because you can go to various businesses around the city of Annapolis and see officers working secondary where their car's parked outside, they're inside in uniform, but they're not there in their official capacity. They're working a secondary shift type of deal. And that's what I'm picturing in this type of scenario. Is it not what we're talking?
Yeah, again, I've been a prosecutor in 2 jurisdictions, Washington, D.C. and Prince George's County. I can't comment on what the police is going to do. What I would say is this: I would say that I trust that our law enforcement officers are going to do whatever the call of their duty is on that particular day. But again, I think the real thing that I want the board to focus on is that this benefits for citizens of Eastport by having an officer presence during certain times after hours, present right there at that location to respond to anything that happens in Eastport. And so this is not just about Eastport Lofts.
All right. Anything else from Andrew?
No.
Rob, do you want to be the only guy who doesn't ask a question?
Well, I think we've covered most of it. Having a little bit of security background, but not in the funding side of it. I was just curious as to, was this going to be a police officer strictly off duty? My initial thought was that they were going to have someone that they hire as security. And I don't know if that's feasible as a requirement as opposed to using the police department. So my first thought was, why wouldn't they have full-time security that's hired by them, by the company?
So I do not think that this agreement precludes security. And that'll be the other thing. It'll be in their interest to have security to deal with whatever it is the issues that they may have on site. This officer or officers, because it's going to be officers that are going to comprise the pool of people who work these various shifts, they're only going to be there probably 4 to 6 hours a day. Again, it's going to be a very limited time in let's say in the evening hours or whatever the case may be. And that doesn't, so they would need coverage the other time. So it just may be prudent as a business practice that they have their own security officers. And I probably would say I have not walked into a building that doesn't have, whether you call them security or concierge or whatever the name they may go by. And so I think that their business practices, I'm going to trust their business practices, that they're going to do what's best in the best interest of their residents, separate and distinct from the fact that they have this agreement with us.
Okay. I'm sure that Ms. Halleck and Ms. Hyatt may have, I'm sorry, Mr. Hyatt and Ms. Halleck may have other things they'd like to address as a result of this, but I'm going to suggest that we hold those till the end because they may apply to some of these other areas as well. So unless there's a strong objection, I'd like to move on to recreation.
I'd like to, I don't have a strong objection, but I can take about a minute to answer a question. I think I can clear a couple things up.
But how many minutes is going to require Ms. Halleck to respond?
I just want to make 2 points and that's it, but I understand.
Let's wait till the end. All right, Mr. Braithwaite, we'll be moving on to recreation.
With respect to recreation, the city took the board's comments to heart, and we actually reduced the space that was available to them consistent with the discussion. And there was a considerable gap. We realized that they would have to provide around 41,800 square feet of public recreational space in order, just 41,000 things. And I believe that may be roughly over 6 acres or so. There's not 6 acres of land to be found in the city of Annapolis in Eastport so that they could purchase and say, hey, Eastport, here's a gift, right? There's no new land. So with that in mind, the city code sets the fee in lieu. Now, I do not think there is any debate all throughout Annapolis.
Yeah.
An acre is 43,560.
Mr. Rogers, please.
Okay, I'm going to accept Mr. Rogers' friendly amendment at over 42,000 square feet. But the essence is, if that's the case, the problem with this is the fee in lieu. But the fee in lieu is set by the city code. So again, we're following the law, and every question I'm going to feel from the board at this point, and I'm already going to concede the point, $21,000 does not seem like a lot of money towards doing whatever. But there is someone in the city of Annapolis that can respond to that, and that's the city council. The city council sets the fee in lieu. So might it be a recommendation from the board that the city council revisit the fee in lieu to make it something more reasonable? Sure. And can that recommendation be made? Yes. But is it also the law by which the city itself is constrained? Yes, also. So that is the problem that we have here. They lack 42,000, accepting Mr. Rogers' friendly amendment. There's $42,000 lacking in public recreational space. They cannot create the space out of thin air. So this code provides for a fee in lieu. Fee in lieu feels a little bit light, but it is the code. We must apply the law. And the benefit of the law in this instance goes to them at a $21,000 fee in lieu.
Thank you, Mr. Braithwaite. Ms. Halleck. You've got a property that we can buy for $2,000?
Listen, I really want to address this issue. The board determined that the project is inadequate and directed the city to revise the standards that are consistent. And that's a really important point that's lost here. The city directed them to create standards to apply as to mitigation and as to other matters here. And again, the goal here is to ensure that the proposed projects contribute and are served by adequate recreational facilities. That's the goal of the code, and that's the whole purpose of the decision here. And that it has to be 500 square feet per multifamily dwelling unit. We know it says or fee in lieu, but I want to look to the code here. The code states that the standards to be promulgated, now listen to this, shall include but not be limited to those two areas. And you got to go back to that and look at it and say, it shall include but not be limited to. It's not binary. There's no requirement that you only do one or the other. So the project needs 49,000 square feet, and initially the total amount of square feet provided was 41,000 and about 500, and that was about 85% of it. 15% was fee in lieu. And when they came back and they looked at it, they found out that by recalculation, only 7,000 is provided out of the 49. That means 85% of it was not, they didn't establish it. So, and the other thing the board told them to do is measure it by going not by a straight line radius. You specifically said that. And they went ahead and did it again. So now they've included, again, on its face, the error, 2 parks that are not within walking distance. Leon Wolf Park, 328 feet, and 5th and Spa Road, 888. And so when you look at actually, you take out those because the way the board measures it, they're at 13% of the recreational space. And that does not even closely achieve the goal of adequate space. And so you sent it back and they didn't add 1 foot of space. They just added a little bit of money, 21,000, despite your articulated concerns on this. And it's one thing to substantially comply like they did with the required space and then have a modest curative fee. Most people are, if you're familiar with the law and how that works, there's always a curative provision and requirements where if you just get close enough, that's the additional amount you can do. But contrary to the city's position on this, it's the city, the director does have the discretion to require in the standards, something has to be met, like 50% of the space or whatever. It has to ensure that the proposed project contributes to and served by adequate facilities. And the revised standards should have included those requirements. And there's nothing in there that says they couldn't do it. And the city failed to consider to require other alternative substantive methods to increase the space. The city's used only this binary analysis, space or fee in lieu. I remember some of the boards saying, look, we're just going to have to hold our nose and deal with this. But they don't, because if you look at the code, it says it shall include but not be limited to. So the city, as a matter of law, fact and law, failed to consider the other alternatives shall include but not be limited to the provision of space and other facilities. Now, they could have done things like required them, it's proportionate. They could have required them to purchase the post office park or tennis courts or to lease or provide a space for a dog park or a playground or arrange for a kayak launch site nearby. The code grants the discretion for them to use other methods to increase this space. And it doesn't add any additional space at all. And it's not enough. If you're going to add 98 units, residents with approximately 234 additional residents. Now I use that number, I used it on the police, and I use that number because that's 2.3 persons per household per the comp plan for 98. And that's the technical, that's the code, that's the way it's supposed to be done. So if we add over 234 additional residents, same thing for the police, calculate the mitigation number, divide it 3.2 by 1,000. These numbers actually make sense. Mitigation requires an officer, that kind of thing. So if you add this plus commercially zoned property that you put these 98 residential units, 234 additional residents to a commercially zoned property which lacks sufficient park and facilities. The code requires that funding improvements to on-site and off-site increase the capacity of an inadequate facility so that the capacity after mitigation will be equal to or greater if the project had not been developed. So by adding that, have they increased the adequacy by the proportion? There are 234 residents. They can't even begin to increase the capacity of this facility to meet that requirement. Mitigation fails here because they don't require anything. 21,000 is not enough to create the recreational facilities for these added residents. And even at proportion, the stated goal is to encourage and I want to go back to this. The board said, I want you to consider adequate public facilities in accordance with the goals of Chapter 22. The goal of Chapter 22 is to encourage new development to occur in areas of the city where public facilities are being provided. This project isn't being built where public facilities are provided. The project is built on a B2 commercial district and was not intended to be a high-density residential area. It doesn't have the adequate recreational space to support a large 98-unit residential apartment building. What little space is in the neighborhood is already overused by the current residents. To meet this APF goal and the needs of the new residents, this project requires a significant reduction in the number of residents or units and a more robust mitigation plan to actually add space. Now, I understand the argument here that it is the discretion and it's not abuse of a discretion. But, and Mr. Braithwaite says, look, mitigation is fine, but it's all proportionate. But the standard has to be met. And the standard, it's an abuse of discretion or a violation of law if you don't meet the standard. And the standard is that this project, the proportionate addition of this project, can't make the facility worse. So, and that's proportionate built in. So if you add 234 residents and you don't add the space and you have options to do that, then you're not making it you're making it worse than it already is. And that's the standard, making it worse than it already is. You can't just say, okay, $1 is proportionate, or that's because we have the discretion to determine that. That is the code and that is the standard. And they haven't met that standard. And that standard is very strong. And they haven't met that standard in police, and they haven't met it in recreational facilities because it's very clear it makes it worse. This project makes that facility worse, and the mitigation plan does not increase it or address that need. Thank you.
Okay. All right, Mr. Hyatt.
Thank you. I want to mention the concept of exemption. I'll use the first minute of my time to do that. I think Mr. Walsh was concerned about that. Each of the criteria state whether there's an exemption or not an exemption. For example, in the case of APF fire, it's exempt from any kind of calculation when you have sprinkler. It doesn't mean that in the case of the police that there's no exemption, meaning there's no mitigation opportunities. In every one of these criteria, there's either a statement that there is exemption or there is not exemption. And the topic we happen to be on right now, rec and parks, there's an exemption if you do something commercially. Then you don't have, you're exempt from consideration. So that's the distinction. And I just wanted to chime in on that before it gets too terribly late and we forget. So when the board remanded this particular issue, rec and parks, it determined that the department had made improper calculations. So the department was directed to support, publish, and apply methods and assumptions used in its calculations of the required public recreational space consistent with the purposes of the APF ordinance. And so what did the Recreation Department do? They concluded that in order for land to count as a park, it had to be open 24 hours a day, 7 days a week. Sidewalks were not to be included as recreational space. The facilities have to have public access, and linkage via streets or sidewalks within this acceptable half-mile radius while having no known safety hazards. So in reviewing this application, the department concluded that the 98 multifamily units required public recreational space of 49,000 square feet. That's what the code says. And then reviewed the location of the Turner Playground and said that didn't fall within the half-mile radius. The post office park didn't count because the city didn't own it. And then it whittled it down so that there was only 7,193 square feet of park space. So, you know, the conclusion of the department was that the balance should be paid as a fee in lieu. Maybe the department determined that the money was needed to support some other park in the area that needed some help, needed the funding. I don't know the answer to that, but it was in the sound discretion within the director of Recreation and Parks to make that decision. And this, again, is pretty formulaic. We went through that at the last hearing, and the big difference between this one and the last one is the your conclusion was that certain parkland was improperly counted. For instance, Ellen Moyer Park is within the half-mile, but we didn't count that, or the department didn't count that because you have to cross the creek. So 22.20 requires a fee in lieu, and the city council determines what that fee in lieu is. It's $250 per unit. So you have a shortfall of 41,807 square feet. And by the way, that's just under an acre. An acre is 43,560 square feet. And you divide 41,807 by 500, and that gives you 84. You multiply that by 250, and you come up with $21,000. So, you know, I don't think it's that complicated. It may be that somebody would like a project like this to spend a fortune and buy land wherever it might be able to find it, but it's proportional, just like Mr. Braithwaite has described earlier under section 22.28. And so, you know, the rationale described in the attachment to the APF certification describes what they were thinking, how they considered it, and that's evidence. That is what they relied upon in making a determination. And once again, I will say that if this board disagrees, you know, I'm not trying to be disrespectful, but it doesn't matter if you disagree with the conclusion of Recreation and Parks. It's whether the Department of Recreation and Parks acted in an arbitrary fashion. Remember, we are on the record, so you're looking at what the Director of Planning and Zoning did in conjunction with consultation with the Department of Recreation and Parks, and that was the conclusion. Do you think that's an unreasonable solution that they came up with? I don't see how the appellant has even gotten close to such a suggestion, and I think that you are compelled to support the determination made by the Director of Recreation and Parks.
All right, thank you, Mr. Hyatt. Questions from members of the board? Christian?
It may be, I'm sure the information is available, but not by readily recall right now, but what is this the largest fee in lieu of in recent memory?
Yes, this is the first exercise of the fee in lieu, so it's also the largest fee in lieu. And
It's the only and largest?
Only and largest, and I would argue, as anyone should, that maybe this number needs to be higher. But again, how can you say we are arbitrary and capricious when we are literally following the law? So again, within the standard of review and everything, should there be a suggestion made to the city council? I would argue so, but again, that's a different question than the question we're here to answer today.
Well, and I will add that it is one of these requirements or code that seems in a semi-urban environment like the city of Annapolis, it is, works at cross purposes. We want to encourage infill development as opposed to cutting down forest land. And we don't have codes and requirements that are necessary and adequately in line with each other. So it is a tricky spot for both developer and appellant. I don't disagree with that. Okay.
Anyone else?
I have a question, Mr. Chairman. Mr. Braithwaite, in the letter from Recreation and Parks, and I'm just asking for a clarification. It says that the recreational facilities involve some on-site spaces, some off-site spaces, and then of course the fees in lieu. What does that sentence mean?
Brief indulgence as I turn to the section.
Yeah, it's the third paragraph after the remaining requirement and the fee in lieu calculation. Do you see that? Page 2, I think. It's just an important paragraph, I think. I just want to make sure I understand it.
I believe that the applicant has a certain planned on-site recreation facilities, whether it be a gym or whether it's open space that they own that the residents can have 24-hour access to, or they're some combination of those facilities, I believe. But I think that question might be properly addressed to the applicant as to on-site services.
And the off-site?
As to the off-site, we have, including in our off-site calculation, we included Davis Park, Leon Wolf Park, Burnside Park, 6th and Back Creek Park, 5th and Spa, and also some additional parkland within a half mile of the site, but we did exclude Ellen Moyer Park.
Okay, thank you.
Did you want, Nadine, did you want Mr. Hyatt to?
Yes, please.
Yeah.
Thank you. It doesn't count as public recreational space, but there's a courtyard for residents. It's partially open to the public, but not fully. And that doesn't count as part of the 7,000 some square feet, but there is that on-site opportunity for the residents.
But it's not open to the public.
No, it doesn't count towards that 7,000.
Okay.
Yeah, right.
So there isn't anything on site.
Not open to the public. So we had to go off-site for the 7,000, because if you recall, we had proposed that, but the decision of the board was that the open area, for example, there's a restaurant patio, and that didn't count. I mean, that's still there, but it doesn't count because it's not open 24 hours a day and not owned by the city.
Okay, thank you. So Mr. Braithwaite, since there isn't any on-site space, does that change anything? I'm just
No, because it wasn't included in our total calculation of space. If that number was included in our space, then that would decrease the total fee in lieu in the equation. So that was not included in our number. Our total square footage, 7,193, was found by only looking at park lands outside of the site.
So why did the director include on-site in his letter?
I believe that might be errata or but while it's included in letters or word, it's not included in our figures. So to the extent that there's a typo or something of that nature, I don't think that undermines the director's decision.
Thank you, Mr. Chairman.
Any other questions from board members? All right. Shall we move on to traffic, please, Mr. Braithwaite?
So with respect to traffic, the traffic, what must be understood, while traffic and non-auto transport, there are flip sides of the same coin. They are married, and I think one of the proposals moving forward is that there may be a rewrite to somehow combine it in a way that makes better sense than it is currently. But until we get there, what we have is this: at the intersection, we noted that time and signal should be optimized, and in order to have the intersection operate at LOSC during peak hours. And then we noted that there should be a donation of $10,000 towards a signal refreshment requirement to meet the condition. But we also note that there are certain things that are not feasible for us to do based on the geography and the road path and other things like that. So one of the things we cannot do is we're going to have issues with our buses' ability to operate on these roads. So with that in mind, you have to kind of read our attachment C with attachment D in order to get the full impact of what it is that we are trying to accomplish using both sides of auto transport, being the traffic side and the non-auto piece to it. So what I would note is this. We would readily accept as to any of these plans, there are other plans that could have been developed. But again, that's not the call of the question. The call of the question is, was the plan or the agreement clearly erroneous, arbitrary and capricious, unreasonable, inherently unreasonable, such that it must be overturned. So what I would implore the board to look at in terms of the totality of the agreements is whether these agreements bear a proportionate, as the law requires, a roughly proportionate relationship to mitigating the issue, or does it cure the issue? I would submit that none of these agreements cure the issue, but that's because of the limit of the law, which is that we cannot impose upon this applicant to solve all the problems of the city of Annapolis. They have to do their part, and we submit that these agreements help them do their part and to mitigate the issues that they would create, and also to make sure that traffic, a huge issue in the city of Annapolis, and we understand and we appreciate that, but it is not that this applicant can or has the ability or the physical ability to alter the actual configuration of the land. And a lot of our LOSC operation is because of our configuration. We are an old city. We are a historic city. And as we developed, we did not develop with development in mind, if that makes any sense. We did not develop to accommodate some of these buildings that now can exist or that are now possible. So it's how do we best strike the balance between dealing with what we have and trying to make significant improvements. So I will encourage everyone to read attachment C and attachment D together, as the combination of those two agreements is what actually gives the full impact that we would have on traffic. So with that in mind, if we look at attachment D, which is the non-auto agreement, the non-auto agreement talks about providing bike lanes with shallow markings. We are going to be asking that they add bike racks and bike service stations within the development. We noticed that we also required a ADA compliant sidewalk along the west side of Norman Drive. We're asking for coordination with the Departments of Works to update the crosswalk markings at various intersections. And again, The I that all these, all what we're extracting from all these agreements are agreements that benefit the public as a whole, right? So what we are upgrading the crosswalk markings at Chesapeake, Bay Ridge Ave, Madison Street, Bay Ridge Avenue, and Monroe Street, with the applicant being responsible for the restriping. We are continuing to push for the evaluation of sidewalks to make sure that they have adequate width within the ADA. And then we are also requiring that the applicant use appropriate State Highway Administration details for any approval of the widening. And now the one thing that is reflective necessarily with the traffic is the discussion about the stop sign ward analysis. Now, there is, I think, a very viable question about whether we should perhaps be including a stoplight or some other measure, or rather, should it just be a stop sign or should it be a stoplight? What should we do at Americana and Chesapeake, or Chesapeake and Bay Ridge? With the stop sign warrant analysis, we'll understand what we're going to do, how we're going to do that, or move forward with that. And then there's also a $10,000 donation in attachment C that will allow us to take care of any signal refresh requirements or anything else that we do. So again, they are paying their fair share to move their neighborhood forward together. So I want everyone to think about it in that regard. Or everything that they're doing here, it's about improving our Annapolis public facilities. So the one thing that you would note here, it's we are trying to encourage the use of our public transportation system. And so we talked about a voucher and to encourage more people that live in, more families that live in the building to use the bus, right? And so for every unit, for a one-time event for each unit to promote ridership. So there's a subsidy that they're willing to provide to cover the cost. And that's not itemized as a total cost, but there will be a fee attached to that, of course, that it's measurable in number because it's a 30-day pass for each residential unit. And then again, the signal optimization at Bay Ridge and Tyler Ave. So I'm going to close my comments, but I'm going to ask that non-auto and auto be considered in tandem because that's the way we thought about it when we were creating when we were having our negotiations and creating these agreements. Thank you.
Thank you, Mr. Braithwaite. Ms. Halleck, you may address traffic and not auto serially or together as you wish.
I'm just going to say, wow, this is a new, what the city doesn't provide for any mitigation for traffic. They're trying to bootstrap the non-auto on there to say, like, we really are doing something. These are two separate and distinct facilities that require different and distinct treatment. And mitigation requirements are planned for both of them. You just glossed over the whole problem with the traffic. And then you said, well, all that's required for that traffic impact mitigation is to do $10,000 for signal light timing. This project is going to add a ton of traffic problems. And let me just I'm going to go through what we talked about. I'm taken aback. Let's talk about the goal of the APF, because that's where we start. It's to assure the proposed development fits harmoniously into the fabric of the community and encourage new development in areas of the city where public facilities are. You say this is an old part of town and you can't do very much. Okay, fine. So let's redevelop it. Let's put a 2,000 person apartment building in there and see if the traffic is. That's your analysis. It cannot make it worse. And if it makes it worse, you have to fix it with mitigation. In the initial APF report, the city relied solely on the findings of the traffic impact analysis in its summary conclusion. And in the course of finding the facility inadequate, the board recognized significant flaws in that traffic study due to the failure of the city to comply and adhere with the traffic impact analysis. And there are so many flaws with that traffic impact analysis, and you didn't order a new one. And you relied on that to come up with your mitigation plan. So let's start with the failures of that. The failure to collect the data on 3 days when only one data was collected on 1 day and only for 4 hours. The failure to collect data at peak hours. The school release hours were not included. These violate the standards set by the city. The improper use of the outdated and stale data that were collected in the spring of 2016 and which were more than 3 years old. A new impact study the data needed to be collected and amended. You can't just take the old one and then rely on it for your mitigation, which is what you did. Where the standards require, the standards say it has to be less than 3 years old. The failure to cite important data from outside the study, Dr. Chen noticed this, none of that was included. They didn't fix it. The failure to include the consideration of the impact of traffic accidents, community events, and poor conditions that are a common occurrence in Eastport. The data, as one of the board members noted, the report was based on the collection on one sunny, uneventful day in September. The failure to consider the impact of anticipated traffic problems at the outflow arteries to the peninsula, such as routine flooding on Compromise Street and accidents on Forest Drive. That was all discussed and that was all presented. And the failure to consider the placement and expected impact of both the exit on the parking garage of the project so close to the difficult and unsafe intersection at Americana and Chesapeake. We focused on that intersection. And in that same location, there's the impact of the delivery truck traffic and the post office. And there was a direction to go reconsider that. The failure to use updated ITE manual for mixed use project for the trip generation calculation. In other words, this traffic study only considered the residents and not the restaurant and retail that are going to be added into that facility. And based on the testimony and evidence presented in the observed conditions of the streets and intersections surrounding the project, this board found that it's deficient and inadequate. And hold on one second. The board ordered the city to address the deficiencies identified in the hearing and reevaluate the facilities in accordance with the goals and requirements of Chapter 22. The failures in the traffic study to comply with the city's traffic study standards and to consider the contributing adverse traffic conditions as identified by the board, unless addressed and corrected, render the traffic study invalid. It's invalid. It can't be used the primary basis, which it was here, that the traffic facility is adequate after mitigation and requires little or no mitigation other than the signal light timing and turn lane removed. The signal light timing was already a requirement in the initial APF approval and was deemed inadequate by the board and not enough to bring the facility to inadequate. And for the record, the director's report says that the traffic study it relied on was attached, but it wasn't. And no new one was submitted by the applicant or the city. The November 16, 2016 Leonard study was submitted as applicant's exhibit A7. The city didn't require an updated or revised traffic study be completed after the remand. Instead, with little or no explanation in the APF report, the director overlooked the study's flawed data collection, analysis, and findings, and again relied on it to determine in the new APF report that the mitigation plan is adequate based on this study. The director's report is confusing. If you read it, it starts with the statement that the facilities are adequate and summarizes the findings of the traffic study. The report acknowledges the study found 2 failing conditions. The signalized light at Tyler and Bay, which Bay Ridge we all know about, that's the signal light timing, and the intersection at Americana and Chesapeake, that's the problematic one. It operates at an E. The new report acknowledges that the prior APF traffic report included the required condition that the Americana intersection be configured and a dedicated turn lane be added to fix the queuing and the wait time problem. That means that the cars that are waiting, the traffic queuing, they can't turn left on Chesapeake from Americana. There's a backup there. Putting in a dedicated left turn lane improves that. So the cars can turn right and reduce the backup. That's what was in the first report to fix it, to make it from a failing intersection at E to a C or a D. But the new report in response to the remand, which is why this is confusing, the new report says that the several roadway improvements proposed in the traffic study have been included as required mitigation. So the traffic study says you have to include that mitigation, which includes the turn lane, dedicated turn lane. The roadway improvements recommended are signal light timing and the turn lane, dedicated turn lane. But yet, take a look at the mitigation plan. It only says signal light timing. The creation of the left turn lane at the intersection was removed due to the insufficient turning radius for the buses. So you can see what happened here. After the report was issued, someone looked into it and correctly realized there isn't enough room there for buses and trucks to turn and to allow the addition of separate left and right turn lanes. This is what I pointed out to the board at my presentation at the last hearing. The intersection is totally problematic with cars lining up to turn left. The traffic studies that there's enough road space there for the cars to line up to turn left. So if you take out the left and right turn dedicated lane, you're going to get that queuing. That's what the study says, and that's what they identify. And in their second report, they say, but that queuing is not a problem because it has enough storage space. But the report didn't address the added problems from this project, including right there where the queuing is going to occur, the delivery truck face-in parking area, that's the delivery spot for that building, close to the intersection. The delivery trucks are going to have to back into the line of cars waiting to turn left. And where the cars exiting from the parking garage, that's the part, if you saw the plans, the exit right there, that close to the intersection will somehow have to pull into those waiting cars in the storage area, and they'll have to wait in the incoming lane. And this will cause gridlock to this failing intersection. The postal trucks, including the long bed trucks, won't be able to pull it anymore into the shopping center area. And they're going to have to pull out wide in that area. And that's the storage area that's identified as sufficient because of the failing intersection. They'll need room to pull into the street, and they'll have to have enough turning rate. And they're going to need help because there's going to be a big problem for them now to get onto the left turn on Chesapeake because they can't go through the shopping center anymore over to Madison to go out on that signalized light. Those long bed trucks and the postal trucks are now going to add to the queuing because they can't cut through. They used to be able to do that. So in addition to the frequent and serious inconveniences, the situation, emergency vehicles are likely to encounter delays in or out of that area, thereby diminishing response times. Common sense tells you that this project will have a significant deleterious impact on this failing intersection. Now, if you remember at the board's finding, on the oral finding, which is why it was important, the board's members said, look, one of the findings is the chairman found in his oral decision that the determination that the traffic impact related to this project will have a negative effect is wrong. And this is exactly the problem. It will have a significant impact. This project will have an negative impact. So the traffic studies finding that it's no negligible impact is not supported by common sense and clear look at the conditions, nor by the technical findings. The trip generation model relied on calculated estimates for the residential and not the additional commercial use, including that restaurant right in there. It requires the updated mixed-use model, which significantly increases the trip calculation and the added volume at that intersection. The traffic engineer admitted in his testimony at the prior hearing that the mixed-use model was not used. Only the residential portion was used for that. The traffic report, while minimizing the expected impact, still determined that the traffic from the project will increase the queuing on Americana. It rationalized this by stating there's enough storage space, but no effective discussion in the analysis was provided as to the problems that are caused by those cars lining up and waiting, and where the parking garage dumps out, and where the delivery trucks pull out, and when the post office. This area will be a huge problem with the proposed design, and all of those cars will add up for the 98 units in the apartment and the restaurant commercial use. This is the main traffic entrance for the Watergate apartment complex and will have a significant negative impact on the traffic facilities that serve those residents. And the mitigation proposed for it, zero, because they took out that turn lane. And the traffic and the timing of the light all the way up on Bay Ridge is not going to fix that intersection.
You're running short on time, Ms. Howe.
The approval only requires signal optimization. It's based on erroneous findings of fact and an error of law and abuse of discretion. The recent claim that the $10,000 is an additional contribution to something else other than light timing is disingenuous. The mitigation plan doesn't fix it, and it makes it worse. A new traffic study must be required, and mitigation for the failed project for that intersection needs to be done. There are missed opportunities, again, as the board would say it. Other mitigation, they could have added portion for the signal light. They could have required four-way stop signs at Americana Monroe intersection, redirecting traffic one way down Americana, the relocation of the parking exit to the back and the loading zone to the back of the building and away from the intersection. The mitigation plan regarding traffic does not, as a matter of law and fact, address the inadequacy of the traffic impact, and it's not making it equal or greater if the project had not been built. It's an abuse of discretion for Director Nash to determine the impact of this increased generation of trips will have, and commercial space will have negligible or no impact on the traffic and facilities. It does, and it's not, its additional traffic and cars are not mitigated, and where there is zero, they have not met the standard. I will address non-auto separately.
Yeah, well, you've only got 6 minutes left.
The non-auto issue, if you want me to go, it's a pretty big one, and I'm going to go quickly. The widths of the sidewalks, partly in front of the building, are insufficient and unsafe. The other deficiency that you noted, that there's no dedicated bike lane, and there's no, you also noted before, there's failure of multimodal transportation hub. There's nothing there. That there's supposed to be bikes facilities throughout the site. They only have one. The lack of crosswalks at Chesapeake and the bus stop were a problem. What I liked here was the board noted the evidence shows the director's certification ignores multiple opportunities to advance the stated goals of the non-auto APF, and perhaps more importantly, fails to address the purpose of APFO to assure that the proposed development protects the health and safety and promotes general welfare of the community. These overlooked opportunities include widening sidewalks, reconfiguring the road, and insertion of a safe bike lane. Now, what happened here is 5 out of the 8 conditions, they required 8 mitigation conditions. 5 out of the 8 were already approved in the mitigation plan, are already required in the site plan approval. That's the letter that was issued by Tom Smith to Alan Hyatt on November 16th in 2018, and it requires all of that. So this mitigation doesn't add anything. It doesn't fix it. It's already been determined inadequate. That includes painting bike Sharrow markers on Chesapeake Avenue. They're already there. They're already on there. Placement of 2 bike racks on a bike service station adds nothing because a multimodal transportation hub is already required to be put in there, including Uber and Lyft. You can't take that out because it's site plan approval. If you take those out, the site plan is not adequate. And repainting and updating the sidewalk crossings in front of the property at Americana, Bay Ridge, and Monroe adds nothing because they're already there. Require that the sidewalks are ADA compliant, be 5 feet or more. That and if there's an obstruction, but there's no obstructions there. If you go and look, the way it's designed, it's inside a telephone pole and there's no obstruction. So it doesn't increase it in any way. The signal light timing optimization was already required in the site plan approval. The 3 modest new conditions are installation of a 4-foot sidewalk on the other side of Norman. That does nothing to fix the front of the building and the side of the building, which are a problem. And the coordination with the DPW to conduct a stop sign warrant analysis at the intersection does little because it just requires them to look into it. And that's what they did before when they did a crosswalk warrant analysis at the bank there. And they came back and said, it's not appropriate because of the conditions. or that we put a left turn or a right turn lane. The conditions didn't allow it. What's to ensure that that's going to happen? Nothing. All it says is study it. There needs to be a requirement, just like the police need to be bound to the 50,000, not up to. There needs to be binding on the department. They're required to give the applicant $80 to give bus passes. Did anybody catch that? Because the new standards say one annual pass, an annual pass for the bus. Did anybody pay attention? So what they required in their mitigation, and how much does an annual pass cost? $500 a year. And they said to all residents. And so what did they require in mitigation? 30 days. $50, it's $80 per non-student and 40. They only said 30 days in violation of their standards, their new standards. And there's no explanation why they didn't do it. So they didn't even require it. And it's a one-time thing, not every year or consistently to provide it. It's just for those residents as a one-time. So if a new resident moves in, they're not required to do it. So they completely watered down their own standards and didn't meet it. And I don't know if anybody else caught that, but I'm shocked by that. The mitigation conditions don't correct or mitigate the inadequacies found by the board in its decision. The project will add residents and their guests and will draw customers to and from the resident and the commercial facility. The minimal conditions don't reduce the negative impacts from the volume and use and the needed. The sidewalks are not wide enough, and it doesn't add anything.
That's about it for your time.
Just give me just one more thing. And I just want to make this, because there was one other important matter. The board directed the city to go back and look at the 14-foot widening strip to see if that's an opportunity to be able to place the Uber Lyft multimodal unit center. That was something that needed to be done also for stormwater. That wasn't done, and it wasn't done properly because the city didn't, all they said is they didn't do it. If you looked at the evidence presented just briefly, the highway was 40 feet wide when it was donated when it was transferred to the city in 36 by a deed. And it was then the widening strip says from the curb on the edge of that 14 feet in. The road today is 40 feet wide. You can't argue that the road was widened onto that strip. That strip is 14 feet and it moves inward, and they don't own that strip and they don't have access to that. So the impact of that decision means that the required multimodal transportation hub has to go in the only area they can do it, because there's no parking all the way around, has to be right by the entrance, one-way entrance on the other side of Madison, between Madison and the intersection of Bay Ridge. This is the intersection we've talked about as being super unsafe. So the sidewalks cannot accommodate that at that difficult intersection.
All right, thank you, Ms. Halleck. Mr. Hyatt, I think everyone will be in better condition to pay attention to what you have to say if we take a 3-minute yoga break or whatever you like. Let's be back in 3 minutes, please. I like the wood panel backgrounds for Mr. Hyatt and Dr. Chen. It makes you guys look smarter.
Yeah, we are.
Well, you can fool some of the people some of the time.
Yeah, that's right. Image is everything.
All right.
I'm gonna go get some wood real quick. You'll excuse me.
Okay, we're just waiting for Ms. Halleck, I guess. I'm sure she wouldn't want to miss a word. of what
No,
Hyatt has
thank you
to
for your
say.
patience.
All right, Mr. Hyatt.
All right.
Listen, excuse me if I may address the board quickly. Listen,
Yeah.
I get that you want to limit this in the time and how to do it. But I want to say that you did advise me that I had an hour and a half time. I have timed this and my presentation very carefully and budgeted my time. And I get that you've broken it up into 10-minute sections. And I get that you want to do it in that way. It only give me 10 minutes. Some of my sections were longer and some of them were shorter. So by doing this, you're kind of crimping on the ones that I needed a little extra time on. And I just want to make another point. Give me just one more minute here on the sidewalks, because I think it's important for the board to understand what a standard is. All right, so one of the things that the city had to do was go back and develop standards. And that's what the discretion of this planning and zoning director did, and do standards. And on the sidewalks in particular, because this is the issue of safety and health of the community members. And if you got out of 10 letters, pretty much everyone is upset about the traffic and the sidewalks and the walkability, because that's what is a signature element of Eastport. And what the city did is went back and developed standards which you required, but the city didn't develop any sidewalk standards. They just said ADA compliant. Does anybody here know what that is really? There isn't really one. There is no ADA specific requirement there's a minimum of 5 feet, and that's not really discretionary. And if you go to the ITA trip manual, that standard operating practice, they recommend wider sidewalks depending upon the type of project. So they refer to the city DC standards, and the city can and should follow those standards. And one of them, they say, for residential, they require 6 feet or minimum. For mixed use like this project, they require 8-foot minimum. And for a heavy commercial site, they require a 10-foot minimum. This is what I wanted Dirt, my expert, to testify to. And the fact is that here we are in standards, and do we meet those standards? The city failed to put adequate standards in, and those are reasonable. And then to the failure to require what are very narrow sidewalks to add anything to this project doesn't make them adequate. So they're not adequate the way they are. And the board, as a matter, it's res judicata. You've already determined them to be inadequate. So how do you mitigate this problem? How did they mitigate the narrow sidewalks? The board found you can't get around that. There is no mitigation on the front or the side of this building. And that is an important part.
You've made your point. Thank you, Ms. Halleck. All right, Mr. Hyatt.
All right, thank you, Mr. Chairman. Ms. Halleck was taken aback, she said, when she reviewed the traffic response, and that there's a ton of traffic and it was simply false. You know, she's not a traffic expert. She never produced a traffic expert. And what happened here is that a traffic impact study was required at the time of an application. It was performed and updated. Just because there's been a lengthy appeal doesn't mean that the applicant has to go back and do a new traffic impact study that satisfies the appellant. That's just not how it works. The capacity of the facility after mitigation has to be equal to or greater than if the proposed project had not been developed. That's the standard in the code. That's 22.28. And regarding traffic impact, you may recall that the board, when it remanded this case, told the Department of Transportation, or told the applicant that the Department of Transportation applied an erroneous legal standard, concluding that there was adequacy because the traffic increase related to the project would have a negligible impact. That's what was the, in your opinion. And the board directed the department to publish its standards and apply those standards to traffic impact. And that's exactly what they did. The Department of Transportation, first of all, required a traffic impact study. And this project, the applicants submitted a traffic impact study based on 127 apartments. Through the site design process, the number of apartments were reduced to 98. So you already have excess impact because it was based on 127. So under 22.21, the traffic impact studies required based on when you have 250 or more daily trips based on published standards by the Trip Generation Manual by the Institute of Transportation Engineers. So that was done because of the amount of trips. And then the traffic impact analysis had to be prepared based upon a scope of work and methodology under a uniform scope of work, not something that the appellant would like to see or a board member would like to see. It's based upon the guidelines that are part of the city's standards. They have always been published, and that is what the traffic impact study had to adhere to. It's not a decision that the applicant made. It's not a decision that anybody else made. The traffic impact study had to adhere to those guidelines, and it did. Those standards are online and have been online, and after the remand, the Department of Transportation reviewed the traffic impact study as was prepared by Lynn Hart, and it went back to 2016 and was revised again in 2017. When the traffic impact study was done, there was a determination that all the signalized intersections and movements at the unsignalized intersections operated at level of service D or better. As a result, the Department of Transportation determined that the conditions satisfied the purposes of testing for and certifying of adequate public facilities. Regarding queuing at the studied intersection, they did not exceed storage or impact adjacent intersections, and so the department found that the conditions satisfied the purposes of testing for and certifying of adequate public facilities. That's what happened. But you add the project that's proposed, 127 units, but really 98. And then you find that Bay Ridge Avenue and Tyler Avenue would operate at a level of service E during the PM peak hour. And that's when it's tested. PM peak hour, AM peak hour, not when school buses are on the road or anything like that. It's a uniform test. So at the PM peak hour, level of service E results if there's nothing done. So the same is true at Chesapeake Avenue and Americana Drive. That operates at a level of service E. So the Director of Transportation, after reviewing the standards properly published in light of the traffic impact study, concluded and made the recommendation that at the intersection of Bay Ridge Avenue and Tyler, the signal timing had to be optimized, and that results in that intersection operating at a level of service C during peak hours, and then the queuing along the eastbound approach would be significantly reduced. The northbound approach at the intersection of Chesapeake and Americana should be restriped. That's the recommendation, to accommodate both a 10-foot left and right turn lane to allow vehicles making a northbound right turn to provide separate left and right turn lanes and improve traffic flow. And then the Director of Transportation found that based on the traffic impact analysis, there was no impacts to bicycle, pedestrian, or vehicular safety as a result of the proposed development. And that was the conclusion. If there is a traffic so-called problem in place now, what has to be evaluated is the impact that this project has in making it worse. It can't make it worse. We have to do whatever's necessary to get it back up to even, so to speak. And that's what was done. And you know, it's not the standard, but the reality is 98 units doesn't generate a lot of traffic, relatively speaking. And you know, if it was a 500 unit, 2,000 unit, all right, significant road improvements would have to be made. But these are, I think, relatively minor improvements because it's a relatively minor impact on traffic. The discussion or the argument about traffic flow internally, that's a site design issue. You know, that's behind us right now. This is impact on the public streets. The department did carefully evaluate Americana Drive, and it also stated that the post office was considered. The department says that it didn't apply an erroneous legal standard and that there is adequacy. The standards are published for evaluating roads, and the conclusion of the certification reflects that the applicant has met the standards with the required mitigation. So, you know, the evaluation was made under standards newly published by the city and standards that had been on record that may not have been considered. The Department of Transportation made a reasoned conclusion. It's spelled out in the attachment to the APF approval. And that allows this board that may or may not like the conclusion, but it allows this board to understand that the act of the department was not done arbitrarily. And I go back to the same thing I've said with respect to the other standards. The appellants may not like it, members of the board may not like it, but it is not your responsibility or your duty or your right to look into the rationale of the decision maker as long as the decision maker didn't make a decision arbitrarily. So you have the same thing here with the traffic as you did on the other standards. The department head worked with the director of planning and zoning, reached the conclusion, and this is the result. You can always second guess, you can prefer to improve an intersection here or there, but that is not what is required. And this study is adequate, accurate, in conformance with the guidelines. It has been confirmed by the Director of Planning and Zoning in conjunction with the Department of Transportation. And this is not a de novo hearing where you all can start picking things apart. The question before you is whether the reasoning mind of the Director of Planning and Zoning in conjunction with the Department of Transportation reached a reasonable conclusion based on the information in the record. And it did, and they did. And I think you're bound by that. Would you like me to talk about non-auto, move right into that?
Yes, please.
Okay.
Yes.
I think this one is maybe got the most extensive discussion amongst all of the criteria. The board directed the Department of Planning and Zoning and the Director of Planning and Zoning to consider how the goals could be accomplished and evaluate multiple opportunities to advance the goals and address the purpose of the APF ordinance as related to non-auto transportation. Once that remand came down from you to the Department of Planning and Zoning, the department reacted, and they reacted appropriately. The department developed additional standards to evaluate non-auto transportation facilities in light of the purpose under 22.02.010A. among other things, and determined that, for instance, facilities for cyclists should be part of a network that connects uses. Factors were considered providing for the safe accommodation of cyclists. There was discussion by the director about directness, continuity, connectivity, and comfort, all about the cyclists. In reviewing those items, the bike lane shadow markings in front of the site along Chesapeake Avenue were determined to have enhanced the safe bicycle access to the proposed project, and would provide a direct route for bicyclists and contribute to the continuity and connectivity of the network. The proposed development was directed, and it has already within the development, but it was directed to include bike racks and bike service stations. And then when considering pedestrian facilities, the department considered the following with respect to adequacy. Pedestrian ways should be continuous, direct, and convenient, with grade separation where necessary. Pedestrian ways are supposed to be secure in this project, well lighted with good visibility. Existing sidewalks must be upgraded to current city standards. That's what was said. And curb ramps must be installed or upgraded to current city standards. There's a requirement to install a sidewalk along the west side of Norman Drive. And then there has to be a coordination to update the crosswalk markings at the intersections of Americana and Chesapeake, and Bay Ridge and Madison, and Bay Ridge and Monroe. I mean, those are significant steps that the Department of Planning and Zoning took in response to your remand. The developer was directed to evaluate the sidewalks adjacent to the project for adequate width and accessibility. That's what they were told to do. And you know, what does that mean? Well, that means they have to look at it and make a decision in conjunction with the Department of Planning and Zoning. And by the time you get, as Dr. Nash indicated, by the time you get to an application for a grading permit, you don't get your grading permit until you sign an agreement. It's the same thing with the police situation. There will be an agreement. This is not the time to deal with all of the details and minutia at a hearing. It's the hammer the city has when a project is approved is no permits until documents are signed. And I've been involved in it many years. You don't sign a stormwater maintenance agreement with 6 pages worth of detail at a hearing before the Board of Appeals. When do you do it? You do it when you get your permit. And that's how all this is going to be handled. We just can't do things, and we can't get into the weeds on every issue here. And that's the same, and that's true with non-auto transportation. But there's many requirements, many more than was required or were required before. And you directed the planning director to evaluate this 14-foot widening strip. Continue to hear about this red herring 14-foot over and over and over again. I'll say it again. It's a 14-foot widening strip shown on a plat from 1960, more or less. That 14 feet is not on the applicant's property. It's not part of the applicant's plan. It lies in part within Bay Ridge Avenue. And why didn't the predecessor entitled, Ms. Halleck, do me a favor, don't shake your head. Because the evidence clearly shows that this 14 feet is outside the applicant's property. It's traversed by a road that the city owns, or I should say the city maintains and operates. What happened is that there was not a conveyance of that 14 feet many years ago. Okay, well, that happens all the time. I mean,
Mr. Hyatt, let me interrupt you there. Maybe we can put the 14 feet aside. In the letter on non-auto, the director says that they have satisfied themselves that the applicant may use the 14-foot strip. That's all we asked them to do.
Fine. Okay, so that's behind us. Okay. All right. And so the issue of Americana and Chesapeake, because of public outcry, I think was focused on by the Director of Planning and Zoning. And what's going to happen is that there will be a stop sign warrant analysis. That will take place. And so, you know, stop signs don't just get put up helter-skelter because somebody in the neighborhood wants them. They have to do a warrant analysis to determine whether they're appropriate, whether they're needed. And that will be done here. And if it's needed, then the applicant will put a sign up. And if it's needed, the applicant will put up pedestrian signals. So all that was added to the non-auto transportation requirements. And there was a directive concerning how crosswalks were to be marked and delineated. You know, there's other treatments to be considered. For instance, Dr. Nash said that raised medians or raised crossing islands on multi-lane roads may have to be installed. There would be this pedestrian signals where warranted, as I mentioned, where serious pedestrian problems might exist. There's going to be a reduction for the exposure for pedestrians, providing curb extensions. I mean, these are all things that are going to be done in addition to and in follow-up to your remand. So we have a mitigation agreement that recites all these. This business of giving a bus pass to the residents, the idea is it's not about money, it's to try to get people to get the hang of using buses. Most people don't use the public buses. So the idea is that when somebody moves into the apartment, they get 30-day free bus pass, and if they like it, great, they'll keep using it. But again, the idea is to try to just get them to start. So this, I believe, of all the responses was extensive. And again, you may not like something or you may want something else, but once again, the analysis and the evaluation is whether this was an arbitrary decision on the part of the planning director. And I can't imagine how anyone could think this was arbitrary given the discussion that was involved in this. So again, I would suggest to the board that this was the Director of Planning and Zoning heard you loud and clear on your remand, and they did exactly what you wanted them to do and properly concluded that adequacy is met subject to the mitigation plan. Thank you.
Thank you. Questions from the members of the board? Yes, Michael.
Thank you, Mr. Chairman. This is directed to Attorney Braithwaite, but if Dr. Nash is more appropriate to answer, if that's okay with you, Mr. Chairman, I'm happy to hear from her. Relative to, just to give me some idea of when this was remanded back to you, can you give me some idea of what the planning director and the department, the traffic department did? Did you take a look at any new revisions? Was there any new information as a result of our comments that sent this back to the department that might have caused you to take a second look at what the traffic impact analysis in 2016 revised in 2017 may have not been reflective of? Or just give me some idea of what self-reflection you did about the traffic impact analysis and why it got kicked back to you.
Well, as you know, the Department of Transportation does this review. They were part of the previous appeal. They heard the concerns for the traffic impact study, and they revisited the study. They noticed, again, as Mr. Hyatt mentioned, the original study was done for a much larger number of apartment units than what is currently proposed. Also, we looked at the data of intersections, traffic counts in the time between the original traffic study and the current time, and found that they were pretty similar. we decided that after talking to the traffic consultant, that the traffic impact study was done in accordance to our traffic impact study guidelines. It was done in accordance to national best practices. And we've also met with our regional metropolitan planning organization and had a discussion about traffic impact analyses, and found that our traffic study guidelines are actually some of the toughest in the region in terms of what kind of intersections the radius of intersections that we study, and the safety requirements. So we feel that our traffic impact study guidelines are very strong. I understand that a lot of people don't always see their anecdotal experience of traffic reflected in traffic impact study guidelines. But the fact is that these are national standards following ITE procedures, and that is what we use. We also looked at the trip generation manual that was used in the study, compared it to the more updated version, and found that the updated versions had lower traffic generation rates, which means if we had used the new traffic manual, if we had used the new number of units, there would be even a smaller impact from this development than what we found originally. That means we were very conservative in our analysis and in our requirements. So, we considered all of that again. The Department of Transportation looked at everything again, and they found what they reported in their analysis. And as far as Americana and Chesapeake intersection, that doesn't have a very good level of service. So when you have a situation where you don't have a very high volume of cars, you look at queuing and you look at the volume and capacity ratio, both of which were found to be adequate. But what will help that left turn out of Americana is if the stop sign warrant analysis for the intersection near the PNC Bank finds that you do need a stop sign there, it will make it so there are more gaps in the traffic, and it will be easier to turn out of there. So that will benefit that intersection as well. If the stop sign warrant analysis finds there's no warrant for a stop sign, so we will not be able to put up a stop sign based on national engineering standards from the AASHTO guidelines, then there are other ways to slow down traffic to make sure that there's adequate gaps for people to be able to turn left out of Chesapeake. And that is what we intend to use the money for. So that summarizes what we did to address this facility.
Obviously the left-hand lane turn that was proposed.
I'm going to jump in for 1 second, and I apologize. But here we are with an exhibit, with a witness.
I object. I absolutely object to the process of attorneys breaking into question witnesses. That's the province of the board, and I'll state my objection for the record.
Right, and I would likewise object. She has no business asking these questions now.
I'm simply objecting to the process here where we're not supposed to have witnesses, and you're asking the city engineer or the department questions. I don't have the chance to put on evidence. You didn't let me because it's on the record. But you're going to allow all of this that's not in the report. It's not in the record.
Ms. Halleck, please. I understand the problem. I didn't anticipate that we were going to have a witness that came up in connection with a question from the chair. We're not going to have witnesses. If Ms. Halleck has some questions she needs to ask Dr. Nash about what Dr. Nash has just said, fine. Otherwise, we'll just disregard Dr. Nash's responses to the question from Mr. Walsh.
That's fine, Mr. I'll direct my questions to Mr. Braithwaite properly.
Yeah. All right.
Mr. Braithwaite, the original finding of adequate public facilities for traffic in the traffic impact analysis that was done called for a left-hand lane turn out of Americana Drive, the designated left-hand lane turn. And in attachment C, after point 1 about the traffic signalization optimization at Tyler and Bay Ridge, there's the statement allowing the northbound approach at the intersection of Chesapeake Avenue, Americana Drive is not feasible at this time due to current bus routing and turn radius needed. Was that not anticipated in the first iteration of the traffic impact analysis? I mean, there was a designated left-hand turn initially, and that was required to make this intersection at a better level of service. And that's what I recall from the initial recommendations from the department. And now it's not there.
Brief indulgence.
Michael, I think I did see in the record the explanation that they couldn't do it because of standards for the turn radius for the buses.
And that's my point, Mr. Chairman. That wasn't seen the first time around.
So our response is this: there are AASHTO standards about lane widths and bike lanes and everything else like that in terms of what the standard widths or what the variance in standard widths could be. And so in the roadbed, our roadbed is city property and the roadbed is fixed in terms of the width. So we're not able to expand city property unless we buy more city property to expand our roads, for example, or eminent domain or some other process where we're able to expand the land that we own. So we are pretty much fixed within the widths, and AASHTO would not allow us to put the turn lane because we wouldn't have the requisite width for all the various vehicle travel lanes. So we are limited by the physical constraints of the roadbed and of the land that we do own to be able to make changes to, and applicant can only make changes to the land, again, that the city owns and the city right of ways, as opposed to any other additional property. And so absent our ability to have the requirements met by the Department of Public Works are the ones who are saying that the lanes wouldn't meet the AASHTO standards. So Public Works is also involved in this discussion to help us understand how many lanes can a road accommodate at any given time.
That's great, and I'm glad that you're compliant now, but it still begs the question of why this wasn't noticed the first time and now all of a sudden it's noticed. Does that not,
again,
if I could finish, does that not mean that perhaps the traffic analysis impact report that is still being depended on, the original report for that was reviewed, and the mitigation proposal that's before us now still is based on that, was initially not taking a look at turn radiuses and other requirements of the roadbed width in that area?
I think that I think that we must focus on the standard of review and who the burden of proof is on. The city has no burden of proof. The appellants they appealed our process going back to June. We are now 5 months later. It'll take probably 4 weeks to do a traffic study. If appellants wanted to present evidence as to expert evidence, because again, I have 2 law degrees. So, and I still do not understand traffic to any degree that I can sit here and profess that I'm somehow a traffic expert. This requires expertise to understand, to have rivaling reports, if you will. There is no contravening evidence. There is no, and we don't bear the burden. What the burden is for us, or what our call is to make sure that when we make a decision, we're relying on expertise, proper expertise. So we rely on the report. Even if you discover an error in the report, are you saying, unless the error invalidates the entirety of the report, which must be a finding, but I'm not sure how do you get it on this evidence. So The burden is on the appellant to show that our traffic study is wrong, erroneous, whatever the case may be, by presenting evidence of what is correct. And that, I proffer, cannot be made by argument. It has to be made by an exhibit, a traffic report, a study. And the study has to match the same level of which our study, so that you guys can have two competing studies from which to choose. The issue is you have one study and you only have one study. There's no evidence to say that appellant has produced evidence which shows that the city's report is not there. We paying attention to the standard of review on the record. We have presented our traffic report. What it will take on this record, on the review, appellants will need to move something into evidence. They will need to present something, a countervailing evidence supported by the requisite expertise to allow you to see why our report is wrong. I understand your point, but the crux of the matter is, if you do have the choice to make at some point whether we are supported by evidence, our decisions are not arbitrary and capricious. If we're relying on experts for our opinion, is that something reasonable for us to do? And I think that that's the ultimate question before you. I don't have an answer as to whether our prior report included something or didn't include something. The burden is on the appellants, and the appellant's burden to present evidence to you as to what should have been or what should not have been in that report.
That's all well and good, but is this not a question of whether the city has the adequate public facilities to provide for this proposed project?
We have already determined that our city facilities are not adequate, and only but for the mitigation plans, that the mitigation plans would allow this project to move forward.
And, if I'm taking Mr. Hyatt's comments earlier about what our role is here, and now hearing your comments about, and I like you, have a law degree, but wouldn't purport to be a traffic expert. But, we are a Board of Appeals, and the city ordinance does allow for appeals to come to us and for us to make determinations. And now the new determination is based on whether the actions of the planning department were reasonable. I don't think I necessarily have to be an expert to determine whether that's reasonable or not reasonable.
That's not my suggestion. My suggestion is not about your expertise.
But I'm also trying to make clear that I'm not going to just sit back and listen to somebody tell me that this is an appeals process and we're just basically going to sit here and let things go because the experts tell us that's true.
No, actually, that's not my comment at all. My comment is that the burden is on the appellants to produce the evidence that you would need to overturn our decision. So it's appellant's burden to present some evidence on which you can rely and say the city's evidence is rejected because the appellant's evidence is superior. We have a superior report. We have a report that's more accurate. We have a report that clearly shows the error in the city's traffic report, and therefore we're going to adopt the findings of this report and reject the findings of that report. That is what I'm suggesting, sir.
Okay, but it's the same report, right? We're still working off the same traffic impact study analysis that was performed in 2016, 2017. Is that correct?
Rather, there is no evidence to go against our report. So we stand on our report. And the other thing that you have to weigh as you weigh the reasonableness of our actions is you have to weigh two things. We're in a public health emergency. So even if we did order the report that's requested, would it show more traffic or less traffic or impact on traffic, even if we were to order it? Was it reasonable for the city to not order a new traffic study on remand? If you believe that on remand, we should have engaged in a traffic study and that was consistent with the board's order to us, then I believe that you understand what you have the power and authority to decide if our actions were reasonable or unreasonable. Now, ultimately, that's going to be your judgment, sir.
Well, to that point, I asked the question about the change from the initial determination by Mr. Gutwald about the left-hand turn lane at Americana. I'm not going to beat it to death, but That was a condition in the first traffic adequacy recommendation. And now it's no longer there because of, now we're being compliant with turning radiuses that, weren't mentioned to my knowledge or recollection that first time around. And I guess now going to what you mentioned, if we're to read both of these sections in concert, going to item 6 in attachment D about the sign warrant analysis, is it fair to infer that stop signs have something to do with traffic impact?
I believe that's almost a rhetorical question, sir. I'm not sure that I can respond to that.
Well, having said that, we're now going to study something that might have been studied in the original study in 2016 and 2017.
Sir, again, it's about the standard of review. This is not the city's burden of proof. The city has no burden of proof, nor burden of production. It's upon the appellants to provide sufficient evidence so that you could see our decisions arbitrary or capricious.
But it is the city's obligation under the code to put together a traffic impact analysis that does take a look at the impacts on traffic, apart from the number of trip originations that take place. It's also a question about other impacts that this project may have of the surrounding area, including public safety and other things. And stop signs would be that, I would think, would it not? And yet it wasn't. The stop sign warrant analyses weren't a part of the original traffic study. So now we're going to study it again.
You have to read D and C together. I'm the original person that conflated D and C.
I'm doing that per your instruction. I'm doing that. And items 4 and item 6 tend to me, kind of go with C, don't they? Following what you had to say.
I would think that the traffic warrant analysis is consistent. It's related to 1 and C. And again, that's not my expert opinion because I'm not able to have an expert opinion.
Fair enough. I'm not going to berate this, Mr. Chairman. In the interest of time,
Thank you.
For other members who may have questions.
Thank you. Are there other members who have questions? Well,
I do, Mr. Chairman, unfortunately have a question. And Mr. Braithwaite, it's just a clarifying question, as I've been asking throughout the evening. Figure 14, it's got both stop signs as well as traffic lights. Could you please just clarify? It's related to the study of the study. And I just want to understand what figure 14 means.
Give me a second.
It's on page 4. Non-auto. It says proposed short-term pedestrian safety improvements by PNC Bank.
And actually, I know I believe I have. So can you please now, I now have the diagram. Can you please restate your question, ma'am?
I just want a clarification of what's what here. So the text refers to stop signs.
Yes, ma'am.
But I see traffic lights as well as a crosswalk. And then I see in the box, the traffic light is a long-term improvement. And yet the figure's entitled short-term improvements. So I'm confused.
So this came from the Eastport traffic study for the inclusion as to some of the long-term improvements. As to some of the short-term improvements, they're more directly related to this project.
So are these traffic lights going in eventually, or who are you talking
If they-
to, I'm wondering, to get your
I'm
advice?
gaining wise counsel on the facts that I may be able to properly address the board. And so Director Nash is co-located with me, and she is providing me factual information that I may accurately answer your questions.
So is she in a sense testifying through you?
No, she is not testifying through me.
No, let me just remind everyone of my earlier admonition that either in response to board questions or your own arguments, the facts you refer to are confined to facts that are already in the record. So we're not having any new evidence. If it's not in the record, you'll have to answer Dr. Chen's question by saying it's not in the record as far as you know.
So this document explains, and this I'm looking for, again, we are in the city's determination of adequate public facilities. I'm on page 24. I'm looking at figure 14. And so this is in the record, and it is our certification of adequacy for public facilities from May 26th of 2020. And I'm on page 24 of our report. Brief indulgence. The 2016 Eastport traffic study advises that installing a crosswalk at the intersection is difficult due to the lack of visibility from the northeast bound traffic rounding the bend. So again, that's referred to in our discussion. So the Eastport 2016 Eastport transportation study is included by reference in our determination. So I do believe that this is forecasting our short-term and long-term improvements that we can make to this particular corner in the city.
So the mitigation plan or the report only deals with the stop signs. It does not say anything about traffic lights. So we conclude from that the city believes what? What is going to help the traffic flow out of Americana onto Chesapeake based on this figure?
So the purpose of the stop sign warrant study and other things is to see whether we can create gaps by putting a stop sign there if it's sufficiently do what we want to do, which is to slow the cars down as they're coming around the corner. So with a stop sign, we will be able to have one car proceed at a time as opposed to the current stream of traffic that exists. So the purpose is to slow down the vehicles as they come around the corner. That way a crosswalk can be effective.
And the traffic lights?
The traffic lights will be determined, they're not currently in the plan, but if it's determined that a traffic light can be implemented at a future date, I'm not sure that this plan prohibits using a traffic light if it's determined that it's warranted.
Okay, thank you.
Christian, did you have something?
Kirsten, you're still on mute,
I think
sir.
Dr. Nash answered it about why they didn't do an additional traffic study.
Well, then you can disregard that.
Disregard. So from the city of Annapolis regarding the traffic study, there were several reasons that we didn't do a new traffic study, including the fact that the first one was conservative because it overestimates the number of units. And therefore, and then additionally, if we were to commission a new traffic study under our new standards, you would actually result in a lessening of the traffic impact from our prior study.
I'm not sure doing a traffic study in the middle of a pandemic would yield consistent results either, but that's neither here nor there.
And then I would say to you, that's when you must weigh whether our actions are reasonable and how reasonable are our actions.
You're answering a question, Mr. Braithwaite, not arguing again. Okay. Any other questions from the board? All right.
I did have a quick question.
Yeah, Rob, sure. Rob, you're on mute.
Using that space button gets you every time. No, a question. Earlier, the appellant mentioned that the traffic study was only based on residential and not mixed use. So I just wanted clarification because I do see where it did address the commercial as well, but just wanted clarification from Mr. Braithwaite with regard to was the retail considered as it changed?
Yes, the retail was considered because in conducting the traffic study, it'll be as it exists now and there's retail in place.
Well, the retail increased though. The amount of square footage for retail did increase, correct?
Yes, and that's the reason the traffic study was commissioned. So it's going to take into account what exists and then what the increased proposed development, the impact that it will have on the current traffic.
Okay.
All right, the last item is traffic. Before we launch, not traffic, but stormwater. Before we launch into that, it's 8 minutes after 10. We're going to adjourn at 11. I'd like you each of the parties to have at least a few minutes before 11 to cover any, final points. So I just ask you to keep that in mind as you make your case on stormwater. Also, it's my intention to invite you, unfortunately, in a compressed time by essentially a week from today, to submit to the board in writing any arguments that you want us to have before we launch into deliberations on the 30th. So with that in mind, Mr. Braithwaite, tell us what you think it's essential that we know about stormwater.
So for stormwater is a very intriguing topic. I have grown immensely as a stormwater engineer over the last 5 or so months. And what I will say is this. One of the crucial points that you must notice in our mitigation agreement, our mitigation agreement talks about 6/27 of the total cost. What we determined that of all the area that services that eventually contribute to this outfall, that the new development will only be 6/27 of the total area of all the different properties in the city of Annapolis that use that end up using that outfall. So we had discussions because we really realized that it can be very costly. We had estimates, I believe it's in the $150,000 range, or actually I could do the math and reverse engineer what's 17,000 is 6/27 of a number.
I'm objecting again. None of this is on the record. You're just testifying what the city did, and there's nothing in your report or anything else. This is just your testimony that's not supported.
I saw 6/27 in the record.
I got that, but the cost or anything else, that wasn't in the record.
Attachment E states that they will provide $17,000 to DPW for the proportionate amount of engineering design work for stream restoration at Back Creek. And then in parentheses, we say 6/27 of the cost. This is an attempt to discuss why 6/27 was the appropriate number and why 17,000 is the appropriate share of the total number that we would need.
My objection is to the cost. You didn't, there's nothing on the cost.
Ms. Halleck, anyone who can do algebra can tell you what the number is that 17,000 represents 6/27 of. Please, let's move on.
And so again, this and this is a part of a series of conversations. The big picture is once we realize that our ask can only be roughly proportionate to what it is that this particular development will add in terms of to our need for public facilities, then in the negotiation, we settled on finding a way to understand what the total cost is and putting a proportionate amount to this agreement. Now, the other thing, appellants had spent, I believe, a significant number, and they have their own stormwater study that's here, and they're going to team with the city to provide technical assistance for applying to for grant funding for the construction work. Because the one thing that we must pay attention to is that this is for the entirety of the city of Annapolis. Eastport is going to benefit from the improvements made. But again, we agree that improvements must be made. We agree that the facilities are inadequate. And in order to get there, we have appropriately burdened the applicant in this case, and with the rest of the other 21/27 of the cost must come from the city or from the public. And that's why we have to look at ways, we have to improve our public facilities, but we're trying to do so in a way that's reasonable, not only to the applicant, but then understanding that the city has to also pay to contribute to improving its own facilities. Now, reasonable minds may argue about, well, should it just stop there or should it go forward or whatever the case may be? But the essence of our determination, again, as to all these determinations, were based on robust thought, vigorous negotiations, many hours of work study and preparation to understand even what the ask is and to make sure that our interactions, which yielded these agreements, whether they were reasonable. All the reasons for which the facilities are adequate are detailed, and that's why my approach has been talking about the mitigation agreements. All the reasons for which the facilities are adequate have already been detailed in each individual report in our adequate public facilities certificate. So this right here, what the mitigation agreements represent is our best efforts and what we suggest is our most reasonable efforts to determine what is the roughly proportionate impact. And that should be the thread that ties all of these various agreements together. And I will yield the rest of my time to someone that needs it more than me. So I guess.
Thank you, Mr. Braithwaite. Ms. Halleck, please. You're on mute.
I note that I have Alderman Ross Arnett here, and usually you take those at 10 o'clock and for the community. So I just wanted, he's there, and I just want.
Ms. Halleck, Alderman Arnett has submitted very thorough and articulate written comments. Is there something that you think he needs to offer orally?
Yes, he only put bullet points. If he could address those issues, I think that's important. I'm going to just go quickly and just to summarize this, and I will yield my time to him on this one. There are about 10 faulty problems with stormwater, and I'm going to submit this as part of my in writing. What are the technical problems? Stormwater is a very technical area, and there are a lot of failures on this project. But I want my issue on the stormwater is I get that the city says it is 6/27, but that's not the point that I was trying to make. Is 6/27 of what? What's required? All they want is 6/27 of the engineering of this project. And then they talk about, oh, we shopped it around and it's going to cost $1 million or no. 6/27 of $1 million. That's what's required, because this project requires, and the board found as a matter of law, that there is significant erosion in the creek bed there, and that remediation is required because this project is dumping high volume water into that creek and causing erosion. And they came back and reduced the amount before the application said, we're going to have them do all of the engineering work. And then they came back and said, no, 627 is about a quarter. We're just going to have them do a quarter of the engineering. But the board directed them to look into the step pool water creek remediation. And that was overlooked and not even they didn't address it, and there's no explanation. Now, that's just one of the things that they're supposed to pay for. The second is the standards are very clear that they're in the adequacy report, that there's supposed to be an inspection of the pipe, and that has to go by their engineer, and that has to be included if there's conditions in there with the pooling, the pilling, the leakage, the damage, and anything else in there. That had to be done, and that had to be included in the adequate facilities report. That is a standard that has to be met, and there's nothing in there that wasn't done. And that all of those exhibits were provided to the city by Mr. Rogers with pictures showing the damage to the outfall pipe. And that needs to be fixed because it's going to fall on the city to have to do that. And a portion of that, 6/27, needs to be paid by the project because the condition of that pipe is a requirement to as adequate public facilities. So that wasn't done. And then the third thing that's huge here is that the city has a new standard and they didn't comply with it in terms of percentage of stormwater treatment required. The city, just like I'm responsible to have to meet the new standards, that January of 2019, the city council increased the standard for treating stormwater from 50% to 100%. And that was done by the city. And furthermore, it wasn't just done by the city, the Department of Public, the head of the department, David Jarrell at the time, issued a letter, and listen, Gregory Brennan submitted the information on this, and I want the board to consider it because it's on the record, that he issued a policy analysis on January 25th, 2019, that 100% of the stormwater must be treated. And the report from this applicant right now is that it's only 74%. So they have not met the standard of stormwater treatment that the city has required, because at the time the project has not been approved. The standards are there and they haven't met them. So what's the third thing that the city what they have to do and they didn't do in the mitigation because they failed the standard, is they didn't require as mitigation treatment of 100% of the stormwater that they are adding to that. So they need to treat, what do you want to say, 6/27. So that's the third thing that they haven't done in this mitigation plan. It's required. And I know it's stormwater. Nobody likes to do it. Everybody wants to go to bed. It's just the most difficult thing. But I'm not going to read it here. I beg you to look at Gregory Brennan's submission. It attaches David Jarrell's letter that requires the higher standard.
I think I've told you that we have reviewed that. The board has received and reviewed that.
Okay, that is a requirement, and that's what I'm going through. So the outfall pipe, the condition for treatment, the outfall capacity is not, it's inconsistent here, and that hasn't been addressed. If there really is 6/27 of their thing, well, the study, the stormwater study says it's 60% capacity. They can use up to 60% of that pipe, but yet they're only allowed 1/4 of it because that's what everybody else has. So that portion was done wrong and is incorrect. So if you're going to use 6/27, you have to be consistent and write your report that says the flow into that pipe is there's only three-quarters of it is used by outlying layers, and 1/4 is allowable for them for their test for the 10-year flow. So the capacity of the pipe is wrong because you've got two standards. On the one hand, you say 6/27, and the other hand, you say 60. That needs to be fixed, and that's it's capricious and not appropriate. And I'm going to, the impervious soil determination, I'm going to submit the documentation as to that, as to how that was done and how that is improper. And lastly is the widening strip. That I know you say it's not, their drawings say that they own it or they don't own it. Well, if they say that they don't have it, the problem is that it's included in their stormwater calculation and the berm area. And their drawings, and I want to readdress this, their drawing, their boundary survey actually clearly shows that they have access to that, and that all of those berms along that front side of the building are used in their impervious service calculation, which affects the stormwater calculations. And if you look into those appropriately, you'll see that their numbers are not appropriate. They're skewed, and the board directed the city to go back and recalculate that. If the applicant's title search, it's the title search and property survey report show that they included that, and that's the stormwater. 19, practically 19 of their 19 or their 22 drawings are wrong for stormwater analysis, because they do include that 14-foot widening strip. Now, if you want to say some of it, their drawings say it's only 7 feet. None of those, that footage is wrong, and it wasn't corrected, and that's capricious and not based on facts. You can't have stormwater analysis to say that it treats the appropriate amount and the mitigation amount that they're required to do. Treat 100%, but you can't do it if all of the studies, everything that their stormwater is based on, is a moving target and includes the wrong areas. I will submit this in writing, but I will submit firstly that I can agree, we all agree that the mitigation may be, it has to create it so that this project does not have more than a negative impact, and mitigation, the numbers, but you have to look at all the things that have to be corrected to have a proper mitigation plan, and they didn't do that.
All right, thank you, Ms. Halleck. Mr. Hyatt.
Thank you. The board, when it remanded the case, properly, frankly, realized and pointed out that the 2018 recommendation of adequacy was a statement, just said stormwater is adequate. That's it. That's what was said. And so that was hard to justify, obviously, because there was no rationale, there was nothing behind it. So once again, based upon your directives, we have another department, namely the Department of Public Works, reacting. So after the remand, the matter of stormwater management, and by the way, there's zero stormwater management being practiced on the site today, none. So the matter of stormwater management was referred back to the Department of Public Works, where standards on the website were considered or were added and published. And then the Department of Public Works determined that, based on the plan submitted, that the storm drain system as proposed and as would be installed if this project goes forward is capable of handling a 10-year storm. That's what the law is. This resolution that desires to do more is a resolution. It's not the law. It's not the ordinance. And the discussion from the then acting director, Ms. Patrick, which is contained in the certification of adequacy, went through an entire analysis. She stated that the project is classified as redevelopment, and based on the volume of stormwater management, it meets the requirements of the code. The ultimate outfall of the storm drain system was inspected and found to be in need of remediation to stabilize. And that's where the conclusion came about the amount of mitigation and the amount of contribution. The department's requiring the applicant to provide what they call preliminary engineering design to assist in the planning approval of a stormwater project associated with the restoration and improvements at the headwaters of Back Creek. See, there's a lot of people that have their stormwater, or a lot of properties that have their stormwater flowing into the creek. And a decision from the Department of Public Works regarding mitigation was that there was some obligation on the part of this applicant, in addition to meeting the requirements of 1710, of section 1710 of the code. There was an addition and a request for further mitigation, which is under the mitigation plan. So this preliminary engineering design was required, and that would assist in the planning of the approval of the stormwater project at the headwaters of the creek. The acting director went on to describe the purpose of testing for and certification of adequate public facilities as relates to stormwater management facilities. You know, the idea is that, again, the goal is to receive stormwater in a drainage area capable of handling the 10-year storm. And that's, you know, that's out of the MDE stormwater manual, as she explained, and the SHA highway drainage manual and the Anne Arundel County design manual. This was Ms. Patrick that discussed all this. She recited that the documentation supports environmental site design. I mean, we have no other documentation to the contrary in the record. And based upon her expertise, her conclusion was that it satisfies the stormwater requirements imposed. And the acting director suggested the mitigation plan of the construction or funding of improvements on site and then off site, as we talked about, the contribution that was in there. And then the applicant is required to consult with the department for review and assessment of each of their facilities as being adequate, and the plans were determined to be adequate. You know, there's a series of rain gardens and all these different features that you may have recalled that are all in the record, and they were all acceptable and satisfactory to the acting director. And then given that the project has been classified as redevelopment and the volume of water required to be treated exceeds what's required by the MDE in their design manual, and the stormwater infrastructure will handle the 10-year storm, you know, we meet adequacy. And what was agreed upon is this $17,000, which again, based upon a certain mathematical calculation, would be contributed to engineering design work for stream restoration. And then this technical assistance is supplied to the city. So, you know, it's a thorough and careful analysis, completely unlike what you saw from the 2018 position from the Department of Public Works. Based upon the properties that feed into the outfall, the determination was made by the director, or acting director, I should say, at the time of Public Works, that this was roughly proportionate, that this was a fair allocation of cost to this particular project. And here's a case again where it is, and I am, I guess, talking directly to Mr. Walsh. You don't sit here as a potted plant. You're a member of the Board of Appeals, but when you have the expertise from the Department of Public Works reviewing the applicant's submittals and reviewing the city code, and there's nothing to the contrary except some far-fetched conversation that we've heard in the past, it's a pretty tough thing to overturn. And I think that you cannot find here, again, that you have an acting director that in any way is acting in an arbitrary fashion. I think that the conclusions are supported by analysis. They are sound. They are in conformance with the city code. They are in conformance with the goals and the purpose of stormwater under APF. And it's entirely correct and appropriate to affirm all of these five, but specifically right now, I'm talking about the determination of the Director of Public Works supporting this. Thank you.
Thank you, Mr. Hyatt. Now, can we have a lightning round of questions from board members? Do we have any?
I have a quick question about attachment E for Mr. Braithwaite. Provision 2, who in the city is going to apply for this grant? Or is it an aspirational comment?
None of the terms of this agreement are aspirational or precatory. They were written, they were reduced to writing because this is the agreement between the applicant and the city. And I will say candidly, it's either the city is acting in the best interest of its residents or it's not. We are a city government. We are not a private entity. We don't act on behalf of any individual member of the public. We act we act for all of us. We act for all of the residents of the city of Annapolis. So none of our actions as a city can ever be infected with to purposely benefit any individual in the city at the expense of all others. That is not how the city would operate. Our calling first is to the public. Every single one of these agreements is an attempt to increase our ability to provide for the public as a whole. And again, to better improve our facilities. So
Mr. Braithwaite, let me interrupt you to reframe Dr. Chen's question. Is there anything in the record that indicates who will have the responsibility for applying for the implementation grant?
The Director of Public Works would have that responsibility because the Director of Public Works entered the agreement with is speaking in this particular attachment. It's Director of Public Works was speaking on behalf of the city in this agreement.
All right, thank you. More questions from the board? Good. All right, Alderman Arnett, I apologize. I didn't realize that that you were waiting to give
Mr.
us.
Chairman, I want to go on record and object to this. If Dr. Nash was not permitted to testify, then Alderman Arnett surely should not be permitted to testify, and his written statement should not be accepted into the record.
Mr. Hyatt, his written statement has been accepted into the record on the same basis as the comments from all the other members of the public. And as I announced previously, because of his status as alderman, we'd be privileged to have him further address us orally on that basis.
The city of Annapolis.
I would object for the record because it's prejudicial.
Your objections noted.
And the city of Annapolis wants to go on the record of fully supporting the right of Alderman Arnett to speak here tonight. He is a member of our city council. He represents the people of Ward 8, and he has the right to he's not a witness here, but he has that right to make the comment that he makes today, and the city supports him and his right to make this comment.
All right. Alderman Arnett, please.
Thank you. And I will attempt to be mercifully brief, even though that's not in my nature. This has been very instructional to watch, and we listened to Mr. Braithwaite talk about how he and the city staff negotiated with the applicant and came up to something that was acceptable to them. I think what's left out of that equation and where the Board of Appeals comes in is the rest of us. We had that ratio of 6 out of 27. The citizens bear the 21 out of 27 rest of the burden to make this all work. And so for me, I look at the standards for mitigation plan is that it maintains adequacy equal to or greater than if the project had not occurred. It seems to me that mitigation could well provide alternatives to the APF rules, but it shouldn't lessen the requirements of those. And I do think that there are opportunities for us to go beyond, as it says, equal to or greater than. I'm not going to go through the points that I make in each one of the 5 areas. You have that from me already. I want to jump right to my concluding remarks. I do agree with the appellants that the new mitigation offered are inadequate. I don't think that they met the standard that this board gave the city to go back and come up with better solutions to meet the adequate public facilities. I don't think they're fair to the residents who bear the impact of the development long after the developers are departed. With all due respect to the city staff, and I know they're put in the middle of these competing interests, I think they need to be more sympathetic, and this whole process needs to be more sympathetic to the impacts and the needs of the residents. The burdens that we must live with and bear are brought on by this new proposal. I would take a quick moment to point out, for example, on the recreational fee in lieu of, if that was $21,000 per year rather than one time only. So this is a project that has an engineering life of 50 years. $21,000 per year to provide for recreation might be fair, but $21 as a one-time only fee just does not feel like it lives up to the bill of being fair to the citizens. So I think that the city and this board should make every interest to protect the interests of the citizens as well as the interest of the developer. And I do want to close by just restating that the mitigation should provide alternatives to the APF rules, not lessen the requirements from the levels of the APF. And it feels to me like all of these negotiations have stepped down from the requirements of the APF to mitigate with the developers and not take into account the interest of the citizens. That was short for me.
Oh, thank you, Alderman Arnett, and thank you for the legislation that changed the standard to 3419. I think that was a courageous and correct thing to do. It'll take us a couple of appeals to work out the bugs of how we do this, but I think it was a good move. That's my personal view. Anyway, so it looks like we've got 5 or 6 minutes each for the parties to cover anything they think is left hanging tonight that they may or may not cover in their written submission to be filed by next Wednesday. So we'll start in the usual order with Mr. Braithwaite.
If the board remembers my first introduction to the board, I think the first time I addressed the board, it was the argument for reconsideration. And what the city said at that point is the city takes very seriously the board's order that was then stayed. We said that we were going to implement certain changes to improve the way that we look at APF. As a new attorney coming in to the city, I too read the prior reports, and we took immediate action to make sure that the board can have a sufficient writing in front of it from which it could really understand the city's thoughts and show you if our actions are rational and allows external party to determine if the director of planning and zoning is rationally based in her decisions or if she is not rationally based in her decisions. And so what you would notice, you should take a look in the record at the old certificate and take a look at the new certificate. The other perspective that you should have is that we did not intend for this to be an on the record appeal, but I think that it's appropriate that the appeal proceed on the record, because this is how the city grows. This is how the city staff grows. This is how we grow our skill. This is how we grow our ability to make decisions and explain our decisions, and then give decisions to people like you in the Board of Appeals to read our writing and tell us if it's sufficient. The reason the city did not include to overburden the record or try to seek exception from the record is because we should be bound by the city's laws. The city council made the laws, and everyone on this Zoom call is bound by the same set of handcuffs, the city code. And since we're all bound by the city code, we're asking you to look at what we did previously, look at your remand. There are lots of assertions made by appellants about what the purpose of your remand is. Only you knew why you remanded it. Only you know what made it to your decision and what your instructions were. Compare what we did previously, compare what we did now. I'm confident that you will find that we have a drastically improved process. We are also learning, and we are going to do better jobs because this is a learning curve for everyone. But we believe that we have carried out our call to the best of our ability, and we pray that you can arrive at the right decision, and which we will suggest is that the appellants who bear the burden of proof have adduced no evidence that can shake any of our findings, that all of our findings were based on expertise, properly exercised expertise, and that the combination of this properly exercised expertise is not a process that's absolutely free of error. No, we have a reasonable process. We have a process that's intended to best explicate our decision-making. We have a process that attempts to now more fully explain ourselves, that everyone may have confidence in our decision-making. And with that, I'll close.
Thank you, Mr. Braithwaite. Thank you. You've always done a great job for us. I appreciate it. All right, Ms. Halleck.
Just to summarize the 5 areas for recreation, this is in the mitigation. Does 21,000 achieve the legal standard here? Does it make this project, the effect of adding this project on the facility, does it make it, we already know it's inadequate. Does it rise it up as if it had not been developed? If you add 234 residents to this that require space, does 21,000 address it? No, the mitigation does not make it, it does not meet the mitigation standard. For police, there's a lot of discussion back and forth, but about who can implement this and how it can be done, but you skipped over it. This, the way it's drafted, does not bind in any way the developer, the applicant, to pay 50,000. This is the same thing that happened in SAYC, where they said, we're going to recommend that they try and make it open to the public. And we saw how that worked. They ended up building a fence around it and said, it says in good faith, unless you bind them, it has to be bound. There has to be an agreement that requires it. There's no requirement of 50,000. It just says we've reached that agreement. If you have, put it in writing, change it, make it so that it has to be 50,000, period. And if you do the math, $47 an hour for 4 hours a week, that's 76,000. That's not 50,000. Number two, they're not bound. But the other thing they could change is everything in the discussion was that it needs to be police officers. Well, it's not police officers. Take out the language of security officers, because they can make it 100% security officers, and they can't do the job of police officers, as I talked about. And so they can't meet the standard with security officers, that the project does not make that facility worse than it currently is, because offsite, none of that was addressed. And all it does is a little bit on-site, but it doesn't do all of the other police. They can't make arrests, traffic reports, everything. It doesn't. So require that it be officers, require it be $50,000, and make that firm, because the way that it's drafted doesn't meet the standard. You can't find it meets the standards. The traffic, that intersection is determined to be a failure. So what is their mitigation? They say that they're going to put a stop sign in. Same thing. They're not bound by it. And we've seen it twice. They just say, we're going to look into it. They said it, we're going to put crosswalks across the way. But the crosswalk couldn't go at the Bay Ridge intersection by the bank because it's unsafe. And there's no showing, there's nothing in here. What if there's no binding. If the stop sign says they can't do it, they have not mitigated it. So if you want to make it a mitigation, it has to be binding. It can only be approved if the stop sign is installed. So change the mitigation plan that says it must be required. And where are all those stoplights and all the other things that are required to actually address the traffic problem? They haven't addressed it. The queuing, the effect of that building, maybe not the number of trips, but the effect of the exit and the entrance and the blocking of the post office egress So it requires those postal trucks to come in there, will have common sense. You don't need another expert. You can see that it will. There are internal problems with that traffic study brought out by other members. It's very clear. They made a fundamental problem by saying it's all going to get better once we have that right turn and left turn lane, but it turned out not. This doesn't meet the mitigation standard. And you're bound by law for that. You have to apply the law on that. And if they don't, if the city doesn't, they say they have discretion. But they have the discretion only if they follow the standards, which they haven't met. Same thing on its sidewalks and for others. That does the impact of this project make it worse? And all the impact we're talking about is not shared on the sidewalks. We're talking about the residents, dog walkers, restaurant people, goers, everybody. The added impact on that facility is not mitigated by keeping the sidewalks the same. It's not mitigated in the front and the side. I'm just using, bike lane is not added. Nothing is mitigated. There's a identified problem. It was held inadequate and they didn't do it. The bus thing, there's a standard that they didn't meet and there's no mitigation for the bus except for they just say a one-time thing. But the standards were issued and there's no discussion as to why they didn't include it. That's for that project. That's what the city requires. And they haven't met the basic standards. The stormwater, same thing. They're required. Now, they say if it's reasonably the ability, they can do it. The early plans of the applicant were to include the step plan pool. We saw that. They submitted it, and so they have the ability to do it, but the city has backed off of it. Okay, it's 5/27ths, but 5/27ths of $1 million is close to 250,000, and the city hasn't, and the repair of the pipes. So how can you say 17,000 meets the standards required? Put a bond on it. How do you do it? You wait, you have them do it. You say it's going to be 250,000 is your contribution to that share of the cost of the step plan pool that you're requiring, and make them post the bond and do it. That meets mitigation standards. Not, well, we're just going to hope, because it's speculative. You have not bound them in any of these mitigation plans to make the necessary repairs or improvements to the facility such that the addition of this project doesn't make it worse. And I believe that if you look through every single one of them, it's not a matter of discretion. They haven't met the legal standards. So it's by fact and by law. If you don't comply with the legal standard, that's an abuse of discretion. You can't just say, I'm 5 cents worth on public parks and meet the standard. So, and the discretion, you can't just say, well, we're the experts and we do it. If we identify the flaws on the face of it, just like we talked about in the last one, on its face, if there are significant flaws, like the traffic study that assumed to have a left and right so it could be adequate. If there are flaws on its face, as we've identified, then it's not supported in the record, and it's arbitrary and capricious, and it's not supported by the facts and the law. And I would suggest here clearly that this mitigation plan is so weak that the citizens, that there's nothing that can be done. And the last argument they make is, look, all of this can be done at the site plan, like the sidewalks. We don't do this now. We want to do it when you're going to get your use permit. Well, at the time you get your use permit, if the building is already up to the edge and there's no width, you can't add width, or you can't move the exit from the exit ramp into that traffic facility, which really needs to be done. You need to move it to the back of the building. Not a difficult thing. Change the flow. There's solutions here. But if you wait to your use permit, you can't get it done. We need to get it all done now. Otherwise, it's too late. If the city can't even do it up front, the city is never going to do it after it's been built. And we ask, we beg, this is a public hearing to hear from us and to hear from the residents. And you've heard, I am it. The whole purpose of this hearing is to hear from the residents to say, this is what we're unhappy with. And I'm the representative. And I'm here to tell you, this community is not happy. This project is not suited, and it doesn't the mitigation plan could have been done right, and the city just caved, and we're upset. And that's what we're here to talk about it. And we are asking the board in a high-pitched voice because I'm tired, but we're really asking the board is to get them to do it right. This building's going to be here for 20 years. Why do we have to tolerate sub-facilities and the strain on these facilities when we could get it right? And we ask you to do that because that's the purpose of this hearing. Hear us, listen to it, apply the law. Don't just walk away because it's easier.
All right, I think we get the gist of your argument. Thank you very much, Ms. Halleck. We appreciate your generosity and your courage taking on Goliath. It's a great service to the community. All right, Mr. Hyatt.
Thank you, Mr. Chairman. First, I'd have to say that this proposed project is a good one. It is a redevelopment of an older center that has a lot of vacancies. It's going to provide 98 units, not 234 people as we keep hearing about. There's a bunch of one-bedroom apartments in there, but 98 units that are somewhat affordable compared to the costs in Eastport. And you have a freshening up of a center. It's smart growth, it's redevelopment, it's implementing stormwater management when there's none today. And let's not overstate and exaggerate the impact on the community. 98 units and basically a replacement of existing retail. Old tired retail with new retail, but it's more or less the same square footage. So we're really talking about what's new, 98 units. It's not all that impactful is the reality. And I don't believe for a minute Ms. Halleck speaks for the entire community. She speaks for a couple of appellants and a few people that have been whipped up against this project. And it's unfortunate. I want to mention a couple of things here and there in my conclusion. This business of a stop sign warrant analysis. What's required here, and I mentioned it earlier, you don't just tell somebody to put up a stop sign because somebody figures that'd be a good idea to put one there. You go through this exercise of a warrant analysis. That is imposed upon the applicant. So if there is a warrant for a stop sign, then the applicant has to put one there. And if there's not, then they don't have to put one there. And then if there's a necessity to put some additional signage, lighted electronic signage for pedestrian access, then that will have to be put there. That's all part of the mitigation plan. And the same goes true for the other aspects of the mitigation plan. It's not at use permit that we're going to sign the detailed agreement. It's prior to getting a grading permit. That's when all of the detailed agreements are signed and they will be binding on the applicant. I would just say that we don't know what the police needs will be for this shopping center and apartments. We have an obligation, if it's built, to spend up to $50,000 in private police protection in addition to the cameras. But that's going to be a police department determination. And I do want to respond to a question. Yes, there has been another agreement, a mitigation plan for a project. A hotel was recently approved as the last piece of Park Place. And what did the police department do there? They required these high definition cameras, a certain number of cameras. And that was the agreement. Did we have a detailed 6-page agreement? Nope. We only had the mitigation plan. And when will we sign that detailed 6-page agreement like we do with stormwater management, mitigation and everything else? At the time we apply for a grading permit. We cannot get a grading permit until we sign the detailed agreement. This is not the time to sign a detailed agreement. I also have alluded to this when we talked about the 5 criteria. This is an interesting first-time case before the board because until recently, the appeals were de novo. And what that means in a de novo situation is that the board stands in the shoes of the planning director. You make the decisions, start from scratch, hear the evidence, call the shots. That's no longer the case. Now you are making your decision on the record. And while that doesn't mean you are robots, it does mean that the appellant has the burden of proof. The appellant has to convince you that by a preponderance of the evidence that the planning department, that the planning director in conjunction with the other departments acted improperly, acted erroneously, acted arbitrarily. That is a high bar. That is not an easy task on the appellant's side. And that's the legal charge that you have. There's deference that you owe to the planning director and the departments because it's on the record. That's 03419. That's exactly what Alderman Arnett did. And in making that evaluation, the record, as you've determined what it is submitted by the city, you have to look at the record to determine whether that reasoning mind reasonably could have reached the factual conclusion the director reached here. That's what you have to do. It's not to engage in any independent original review of the evidence. It's to review what the director did and give deference to the conclusions of the director. It is unreasonable, and I say it respectfully, but it is unreasonable for an alderman to make a recommendation for mitigation when that's outside his charge. It is the responsibility of the director of planning and zoning in consultation with the other departments to make those recommendations. That's, when an alderman makes that recommendation, it's usurpation of the right and opportunity that the director of planning and zoning has. And we went through the various criteria and what each department did. I think that each department, the 5 departments that were impacted here, did exactly what you told them to do. They followed it to the T, because you made it real clear in your March 2020 decision when you remanded the case back. You gave them a roadmap and they followed it. They did exactly what you asked them to do. And that's important because that is what they were supposed to have done. So, it's been a year, almost 2 years we've been at this. You're probably tired of hearing from me, and I apologize for that. But, we have appellants that disagree with everything. I mean, if it's night, they say it's day. They absolutely disagree with everything. They have made these allegations and far-fetched statements and conclusions that are not supported by anything. The city council has spoken. We talk about this rec and parks situation. I didn't make that stuff up. It's a calculation in the code. It's $250 per apartment. That's what it is. Is it inadequate? Well, if it's inadequate, I guess the legislature has to do something about that. But the evidence in the record is overwhelming. The director of planning and zoning has reached a conclusion that is certainly not arbitrary, certainly not capricious, as has been suggested, and it's based on the record before her. I feel like if you take a look at what is in that record and you consider what you have heard, this project will go forward because I think you have to reach the conclusion that the director and her departments did the right thing after you gave them the roadmap to do it. And I thank you for your time. I look forward to a decision that allows this project to go forward. I think everybody will be happy with it, even those that may not like it in anticipation. They'll like it when it gets built. Thank you.
All right, thank you, Mr. Hyatt.
Board, as an appellant, I just want one note. The whole standard of review
Objection.
is represented.
Mr. Chairman, enough of that. That's
Just a
not
minute.
right.
I'm going to read the code.
No, we can read the code, Ms. Hyatt.
It's not just abuse of discretion, but it's an erroneous finding of fact by the
director. We know what
director.
it says, Ms. Halleck. We've read it. And you're going to refer to it multiple times in whatever you file by the 25th. So please.
That's all I want.
All right. So file whatever you want by the 25th. Keep in mind the new standard of review. This is the first case the board's had under this standard, and we're doing our best to work through it. And keep in mind that we're limited to the record. 2 questions that occur to me that you may or may not want to address. The purpose of adequate public facilities, if you read the general sections, not the mitigation section, is to make the facilities adequate. The mitigation section seems to be in conflict with that. Rather than make a facility that's inadequate adequate before you go ahead, it seems to say that mitigation only has to offset whatever impact that facility will have. How do you resolve the tension between those 2 things? And sort of where the rubber meets the road, or by way of example on that, is police. There's a clear standard that we want the 1.3 ratio, whatever, or 3.2 ratio. But then, and we admit we don't have that, but then the mitigation analysis is we don't really have to have that if we have this other stuff. On stormwater, just as another example, I think the rules said, if they don't still say, that if there's stream bed erosion, it has to be corrected. But under the mitigation section, the city's determining that we have to take a step toward what may or may not be correcting it. So those are things that jump out at me. They're sort of big picture issues that we need to address, that the board's going to need to address. And I invite you to address that in your comments, along with whatever you think is important. So with that, that will, if you get them in a week from today, that will give us the long holiday weekend to look at what you've written before we convene again on November 30th. So I will wish you all a pleasant and safe Thanksgiving. Thank you again, all the members of the board,
Bob,
staff. Yeah.
can I just ask that we set a time on next Wednesday?
Yeah,
If
the
you have
staff
to-
is going to want to go home a little bit early on the eve of Thanksgiving.
I would like to have any submittals by noon so that we can do all our technical processing of getting them sent out and loaded.
Good point, Jackie. Thank you. So please get your stuff in.
And you'll accept those documents by email?
Absolutely.
Okay. So there would be no need to submit copies of whatever you're saying, but noon on Wednesday is the
Right.
deadline. If it's not in, it's not getting
Right. We said
processed.
that. We said it.
Okay.
All right. So have a happy and safe Thanksgiving. And someone please make a motion to adjourn until the 30th.
I move we adjourn.
Where's my second?
I second it.
Second.
All in favor?
Aye.